Quorum being present, Subcommittee on Health, Employment, Labor, and Pensions will come to order. Good morning. I would like to begin by extending a special welcome to Secretary Perez, and we appreciate your willingness to engage in open and frank conversations about important issues facing working families and job creators. I know there are areas where we will disagree, but I will always welcome the opportunity to raise our concerns and lay out what we believe are more positive alternatives. I wish we were here to discuss a proposal that enjoyed broad bipartisan support, one that would help strengthen our economy and improve the lives of hardworking men and women. Unfortunately, that's not the case. Instead, we're here to address a regulatory scheme that will hurt a lot of families, retirees, and small business owners, and it could not come at a worse possible time. One of the most difficult challenges we face as a country is a lack of real retirement security for America's families. The defined benefit pension system continues to experience a decades-long decline, while many workers are still rebuilding the savings they lost in the recent recession. Due to these and other challenges include a persistently weak economy, too many workers are retiring without the means necessary to ensure their financial security. And just a moment, I found some information about retirement security by a GAO report, Mr. Secretary, that shows that 29% of households 55 and older have no retirement savings, and 23% have a defined benefit plan but no retirement savings. So it's a real issue, and I'd like, without objection, to have this report submitted for the record. And also another report submitted for the record. The U.S. Chamber finds that the DOL proposed fiduciary rule could impact 9 million small business households, and I'd like to have that introduced for the record also. Our goal as policymakers should be to advance bold, bipartisan solutions that will help more Americans plan, invest, and save for retirement. Regrettably, the Department's fiduciary regulation would move our country in the opposite direction. It would cut off a vital source of support to many low and middle-income families and small business owners rely on, and that is the help of a trusted financial advisor. 4 years ago, the subcommittee examined a similar proposal that was later withdrawn under intense bipartisan opposition. I said at the time that anyone who provides investment assistance should be well-trained, committed to a high ethical standard and ethical and professional standards, and devoted to the best interest of those they are serving. That is why financial advisors have long been subject to a host of securities, tax, and disclosure requirements. It is a complex system of rules and regulations, but is an important one that has worked well for decades. That doesn't mean we shouldn't look for opportunities to improve current standards, but we cannot in any way make it harder for workers, retirees, and small business owners to receive the financial advice they need. Yet that is precisely what this regulatory proposal would do. Offering some of the most basic assistance would be prohibited, such as advice on rolling over funds from a 401k to an IRA. Financial advisors would no longer be able to assist individuals on how to manage their funds upon retirement, and small business owners would be denied help in selecting the right investment options for their workforce, which would lead to fewer employees enrolled in a retirement plan. It's been suggested on numerous occasions that this proposal will simply apply to financial advisors the same standard recognized in the medical profession. Mr. Secretary, I believe you've drawn that comparison from time to time, and it's a clever talking point, but one that couldn't be more flawed. As a physician with more than 30 years of experience in treating patients, let me just say that the approach reflected in this proposal would destroy what's left of our healthcare system. Imagine what would happen if doctors were prohibited from receiving compensation, or were required to sign a contract with each patient before delivering services, or were forced to publish online each and every treatment that had been prescribed the following year. No doctor could run a successful practice under this type of regulatory regime, and no responsible financial advisor will be able to either. Make no mistake, if this rule goes into effect, a lot of people will quickly learn that their financial advisor, someone they have known and trusted for years, will no longer be able to take their call. And it's important to note that low and middle income families are the ones who will bear the brunt of this misguided proposal. They will lose access to their personal service that they've relied on and been forced to find a suitable advice online or simply fend for themselves. As is often the case with big government schemes, the wealthiest Americans will do just fine. And those we really want to help we will hurt the most. Mr. Secretary, this latest fiduciary proposal will lead to the same harmful consequences as the first and should suffer the same fate. Please withdraw this proposal and work with this committee on a responsible, bipartisan approach that will strengthen protections for investors and preserve robust access to financial advice. Our nation's workers and retirees deserve nothing less. With that, I will now recognize the ranking member of the subcommittee, Congressman Polis, for his opening remarks.
Thank you, Mr. Chairman. Today we will be discussing an important issue that's been simmering for several years now. After the Department of Labor chose to modify the first version of this rule several years ago, they've been working to listen to a broad spectrum of stakeholders on how best to proceed. And I think that everybody in the room on all sides of this issue believes in a best interest or fiduciary standard, because I think we're all here out of concern that the client's interest should be paramount. But what this comes down to is how to make that happen and how to implement the rule in a way that makes sense and benefits consumers. I truly believe today that most advisors do what is in the best interest of their clients. And hopefully the final rule won't be an overwhelming burden on those good actors. However, providing a standard that those few bad actors need to abide by is absolutely essential, as well as to improve transparency in the industry. As we all know, most Americans are not saving enough for retirement. It's essential that what little is being invested should not be biased by conflicted advice. Investors should be able to trust the person advising them about the money they need to live after retirement without having to worry about that advisor's self-interest. On the other side of the coin, we need to protect individuals and small businesses to make sure that they have access to quality advice, because mistakes in investments cost billions of dollars, and good advice is well worth the price. I'm thankful to all of our witnesses for coming today to share their experience, and I'm particularly glad that we're beginning with the Secretary of Labor, and I'm glad to hear that he is interested in hearing our feedback about the rule, and I'm thrilled that he has decided to extend the comment period by an additional 15 days. I know that he's been working diligently on an overall goal of expansion of retirement savings as a way to address the retirement crisis. They've been doing a great deal of work in the Department of Labor on financial literacy, increasing effective enforcement by the Employee Benefit Security Administration, providing technical assistance to employers and workers and retirees about saving for retirement. A good workable rule regarding a best interest standard can help increase trust between a client and their advisor, and that's an important part of expanding retirement savings. I don't think anybody thinks that the current rule is perfect, and that's why I'm thrilled we're having this conversation, as the Secretary has extended the comment period for 15 more days. I'll be asking some in-depth questions, both at this hearing as well as for the record, because although I believe that this process should continue forward to close a loophole and establish a fiduciary standard that reflects today's retirement landscape, we also need to understand and fix any unintended consequences, especially for low and middle income investors and small businesses. Ensuring that people are receiving good, affordable, conflict-free advice should be our end goal here, and I look forward to hearing in-depth answers from the knowledgeable questions from the members of this committee so that we can help the Secretary reach an end result that helps those most in need and improves trust in the client-advisor relationship and leads to greater retirement savings for Americans. Thank you, and I yield back the balance of my time.
Thank you, gentlemen, for yielding. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It's now my pleasure to introduce our distinguished witness in the first panel. The Honorable Thomas E. Perez was sworn in as the 26th U.S. Secretary of Labor on July 13, 2013. Prior to his confirmation, he served as Assistant Attorney General for Civil Rights at the U.S. Department of Justice and as the Secretary of Maryland's Department of Labor, Licensing, and Regulation. Mr. Secretary, I will ask you to stand and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give to be the truth, the whole truth, and nothing but the truth? Let the record reflect the witness answered in the affirmative, and you may be seated. Before I recognize you for your testimony, let me briefly you understand the lighting system. 5 minutes, we'll have some latitude with that, with the Secretary here, and with that you're recognized.
Good morning. Thank you, Mr. Chairman. It's a pleasure to be here. Ranking Member Polis, Chairman Klein, and other members of the committee. It's an honor to be here, and thank you for allowing me to come to discuss the department's important efforts to help ensure that your constituents and all Americans have access to sound investment advice that a middle-class retirement requires. Merlin Toffel did everything right. He was a veteran of the U.S. Navy and an electrician. He and his wife, Elaine, raised their 4 kids in Lindenhurst, Illinois, and instilled in them those middle-class values befitting of their greatest generation. They loved to travel, they worked hard, and they took care to save wisely. Over 4 decades, they built up an impressive portfolio with Vanguard. Merlin at the helm, managing the account, and Elaine, an accountant, keeping the books. Life took its toll. Merlin was diagnosed with Alzheimer's. When Merlin could no longer manage their finances, Elaine made an appointment at the local retail bank. This is the bank they'd been using for years. They trusted them. The bank's investment broker told her to liquidate the impressive Vanguard portfolio and sold them variable annuities to the tune of $650,000. Elaine trusted that advice. It was in her best interests, she thought. But those variable annuities charged nearly 4% of the investment per year, or $26,000, the rough cost of buying a new car each year. And if the Toffels needed to access the money right away, as all too many families face when their loved one is in decline, a 7% surrender charge would cost them more than $45,000. In the end, the broker's conflicted advice cost a hard-working, middle-class family more than $50,000. The Toffel story is tragic, but regrettably, it is not unique. Conservative estimates by the Council of Economic Advisors place the cost of conflicted advice at more than $17 billion annually. Our economic analysis shows that conservatively, the amount that savers would benefit from our rule, and this is only based on a slice of the IRA market, would be $40 billion over 10 years. For families like the Toffels, families who've done everything we ask of the American middle class, the stakes could not be higher. ERISA is over 4 decades old. In my parents' generation, average Americans retired after working their entire life in the same company. Their retirement was met with both a commemorative pen and a concrete pension. Because that pension was a defined benefit, the only thing at risk of running dry was the ink in the pen. But times have changed. Defined benefit plans have given way to defined contribution plans. Now consumers are in control of making their own investment decisions through 401ks and IRAs. We can still count on that commemorative pen, but a secure retirement is less predictable. For the majority of Americans without a finance degree, the market is at best a confusing place. I appreciate the fact that you are a very distinguished doctor in addition to a member of Congress, Mr. Chairman. I have 4 siblings, and they are all doctors. And, you know, I'm a lawyer, and I promised them I'd never be a plaintiff's personal injury lawyer, and I kept that promise. No disrespect to any plaintiff's personal injury lawyer around the table. But you know what? As I said, 3 of the most important decisions people make in their lives are medical, legal, and financial. And I know my siblings, the doctors, they understand that they have a very concrete obligation to put their patient's best interests first, just as I, as a lawyer, have an obligation to put my client's best interests first. That is clear. And most people assume that the same holds true for their financial professionals, but that's not necessarily the case. Indeed, many of those working in the retirement space are in fact doing the right thing. Many of them are fiduciaries already, having taken an oath to serve in the best interests of their clients. Yet many more are not fiduciaries, and despite marketing that might suggest otherwise, they operate under no such commitment to do what's in the best interest of their clients. When seeking advice on retirement, consumers are at an informational disadvantage. This playing field is not level. But this is not simply about people who do bad things. I actually think, and I agree with both the chairman and the ranking member, that the vast majority of people who provide advice are trying to do the right thing. I have not heard from anyone who said that I don't do anything but try to put my customers' best interests first. But the challenge is that the system is flawed. They are operating within a structurally flawed system, a market that sees the personal financial interests of the advisor and the firm all too frequently misaligned with the best interests of the customer. So the Labor Department's conflict of interest proposal has a singular goal: to align the best interest of the customer with those of the advisor and the firm. Simply put, we want to create an enforceable best interest standard so that you can have certainty that your financial advisor is working for you first and foremost. This proposed rule is a product of lengthy, exhaustive outreach. It includes extensive consultation with the SEC, whose expertise has been invaluable as we've developed this rule. Our outreach to the SEC was not a box-checking exercise. It was critical to the rulemaking, and it's helped us make a better proposal. The proposed rule was also following very significant outreach to representatives of consumer groups, the financial services industry, and members of Congress. And we appreciate that input that we have gotten throughout the process. We've established a lengthy comment process of roughly 140 days, which is one of the longest that we've done in a rule, and for good reason. Throughout this outreach process, I have been very heartened by the calls that we've gotten from many in the industry to establish a best interest standard. So for instance, John Thiel, the head of Merrill Lynch Wealth Management, said, "Since 2010, we have supported the notion of a consistent and higher standard for every professional that deals with the American investor and those that deal with retirement plans. As an organization, we have provided input to policymakers in Washington. We believe we were heard, and we will have an additional opportunity to comment." CEO of Bank of America, Brian Moynihan, said, and I quote, "We believe that doing what is in the best interest for your customers is absolutely the right thing to do. We have been clear that we see the industry moving, and we expect to help it move there." There is an increasing recognition inside and outside the industry that the best interest standard is, in fact, the right way to go. The debate has shifted unmistakably from what problem, to an acknowledgement of the problem that people providing investment advice should have an enforceable obligation to look out for their customers' best interests. And now the important questions that remain, and I agree with the ranking member, is that how do we operationalize this standard? And we look forward to the feedback and constructive dialogue that we continue to have in that so that we can get ideas on how best to operationalize this. Because leaders of large and small businesses alike have recognized not simply that this is the right thing to do, but it's the smart thing to do. Jack Bogle, the founder of Vanguard, said, and I quote, "For as long as I can remember, I've pressed for a federal standard of fiduciary duty, a simple rule that stresses that clients come first." Mr. Bogle has 64 years in the business, and he said, "I learned early on that when you put your customer's interest first, it's great for your customer and it's great for business." He has retired, but Vanguard's competitiveness has not. And while Jack Bogle, who built Vanguard, understands the importance of acting in the best interest of its clients, so do many small and medium-sized companies. Wealthfront is a relatively small investment advisor, just shy of 4 years old, and they wrote to us recently to say, and I quote, "We were built from the ground up to operate under the full fiduciary standard despite serving small accounts and charging incredibly low fees. Thankfully, our effort to serve the small investor has been rewarded with unprecedented growth. Wealthfront is living proof that not only is it possible to provide fiduciary service at low cost to small investors nationwide, but also that the market greatly rewards these efforts." This is what we're hearing from industry. And what we're hearing is that the rule is good news for both American workers and retirees and everyone who is leaving a job and deciding what to do with their hard-earned money. But ultimately, it's not about simply the firms, it's about the people. The middle-class life rests on 5 pillars: fair pay, a roof over your head, health care for your family, education for you and your children, and the ability to save for you and your family's retirement. I totally agree with you, Mr. Chairman, that we have a retirement crisis. We got to save more. And what we're trying to do in this rule is to ensure that the hard-earned money that people have saved throughout their career can go to them. And at the same time, making sure that we have an industry that continues to be able to do good and do well. You can do both. And I look forward to hearing your questions, concerns, and I look forward to continuing the outreach because it's been a very, very constructive process for the 2 years or roughly 2 years I've been in this job. I've appreciated the input from many members of this committee who've helped us frame an even better rule. So thank you, Mr. Chairman, for your courtesy, and I look forward to your questions and those of everyone on the committee.
Mr. Secretary, thank you for being here, and I'll start off the questioning. I know one of the premises that was made is that we have a crisis, and basically there's a $17 billion number. And being a numbers guy, I went back and sort of dug through how that number came up, how that actually happened. And the way that occurred, the Council of Economic Advisors, the way they put that number together was they took the total value of loaded mutual funds in IRAs and the total value of annuities in IRAs, added them together, and somewhere in the literature found out or determined that there was a 1% difference in that advice and other advice, and that's how and there's 1.7 trillion in the total assets when you add those together, and that's how the 17 billion got there. The problem with that is there are a lot of assumptions and extrapolations when you get to that. One assumption was that when you paid a loaded mutual fund, that you did that every year instead of just going ahead and having the one-time load. I've got a loaded mutual fund in my own retirement plan that haven't changed in 15 years. And it was a terrible example that you gave. I really feel badly for that family that had a 4% annuity and a 7% surrender. I agree with that. That's very bad advice that they got. But making them a fiduciary, Bernie Madoff was a fiduciary. And look what happened there. So making a fiduciary and more rules, and I guess first question I have for you is, do you think all this rulemaking, we've got 29% of people that don't have retirement savings, will make it easier for people? Will it make it simpler and easier for me as a small business person that provided retirement benefits for every employee I had from the day I started my medical practice? Will this rule make it easier for me to set that up and provide for those retirement savings for people, or will it make it harder?
I think it makes it easier for both workers and for employers. And let me talk about workers first. It's a very confusing world for people who want to get advice, because some people that give advice have taken an oath to have a fiduciary obligation. Some people are broker-dealers, and they are under a suitability standard, and some are actually dual-headed. So depending on where you are in the conversation, they're a fiduciary one minute, and they're not a fiduciary the next minute. That's remarkably confusing for consumers. And that's not the case for a doctor or a lawyer. When you go in there, your doctor's always looking out for your best interest, and your lawyer's looking out for your best interest. So this rule makes it simpler by making sure we have one standard. As it relates to businesses, businesses are often victims. And I've spoken to a lot of small businesses who, they know how to make widgets. They're not experts in investing. And what they're often getting is advice that also has the same structural flaws. So when small businesses who are trying to do well by their employees are looking for that advice, this rule is going to ensure that businesses and consumers alike are going to have access to that same non-conflicted advice.
My time is limited, Mr. Secretary, but why would the NFIB and the Chamber, who represent small businesses, object to this rule the way it is proposed?
Well, I can tell you that we've also spoken to a lot of small businesses as well, and one interesting one.
Now, I ask that, why would they oppose? And then to make it easier, these are the rules right here. This is just this is yours right here. This big whole thick thing you have to read through. And let me just go through a couple things. This is what someone has to do now with a BIC exemption to get an exemption, which you provided in there. You did provide a way to exempt for the broker dealers. A total cost of disclosure must be provided to the investor before executing any investment transaction. Disclosure must be provided an all-in cost, anticipated future costs, recommended assets over 1, 5, and 10-year periods, making reasonable assumptions about investment performance, and the all-in inclusion includes acquisition, ongoing, deposition, any other costs that reduce the asset's rate of return. It's very simple. I looked up mine this morning. It's very simple with the account I have to be able to tell exactly what my returns are net of fees. These added, I see some things right here. The public website must be maintained and updated quarterly, showing the direct and indirect material compensation paid to the advisor, financial institution, and any affiliate of the financial institution with respect to any asset that the investor is able to purchase, hold, or sell through the advisor or financial institution over the last 365 days. This is going to be thousands of things that you have to do. Does that sound like it makes it easier?
I think, sir, this rule is very straightforward. You have an obligation, if you're providing advice, to look out for your customer's
Totally
best
agree
interest.
with that.
And, well, that's what the rule says, and that's what the proposed rule says. And what we heard in our feedback was, we don't want a straitjacket. We want to make sure that we don't have to ban commissions, for instance, and the rule doesn't ban commissions. We want a flexible roadmap for compliance that enables us to design what works best for our business. And the best interest contract is exactly responsive to that. Now, if there are questions about how to operationalize it, as the ranking member said, we're having that conversation right now, and we're having very productive conversations about how to make it work. The issue you said about publishing fees, I believe in transparency. The problem right now is that the system is really, really opaque. You don't know what your fees are because there's a lot of hidden fees. And when you publish these and have that sunshine, there will be, I predict, third parties that are going to emerge that are going to start the consumer reports of financial advice. And so consumers are going to be more empowered when you have that transparency.
Okay, let me interrupt. My time's expired. Mr. Polis, you're recognized.
Thank you, Mr. Chairman. Secretary Perez, I want to thank you for your department's work on the lifetime income disclosure regulation. As you know, I'm an original sponsor of that bill, and I strongly believe all workers should have access to this tool that federal workers currently have. In a snapshot, workers will know not only how much they've saved, but also what the balance would translate into in guaranteed lifetime income, very relevant for their own retirement plans. And I know that this particular rule here is also part of your plan to make sure Americans save enough to retire. I want to address a few issues in the rule. There has been questions about the extent to which your department has sought input from the SEC and other regulators regarding the specifics of the proposal. Would you provide some details regarding these interactions and how the department has gone about receiving input in crafting a proposal that marries well with securities law?
Sure. We've had extensive conversation with the SEC. We detailed this in a letter. I've had, I think, 8 different either in face-to-face or calls, meetings with Chair White throughout this process. We provided the day before yesterday roughly 800 pages of documentation to note and document the extent of the coordination. And it's been very helpful. Our career staffs have met countless times over the last 4 years. And as the materials describe, you'll see that they helped inform our judgment in every aspect of the rule. This committee has helped inform our judgment as well. And I want to thank Congressman Guthrie. We had a provision in the old rule that related to ESOPs. And there were some concerns raised by Congressman Guthrie and some of his constituents with whom we met. And as a result of that, we took that out of the current proposal. And so we're going to continue to listen and learn, whether it's from the SEC, whether it's from members of Congress, whether it's from industry. All the stakeholders have really helped us make this a better rule. And I'm confident that the final rule will be even better because we continue to get good input.
Thank you. And as you know, the proposal includes a significant exemption from the prohibited transaction rules for financial advisors who enter into a best interest contract with customers. To use that exemption, the advisor needs to comply with significant disclosure requirements. And my question is around the cost benefit of the amount of disclosures and whether the disclosures actually provide an average investor with information that they can process, and whether that additional burden is worth it. And of course, we've heard from some advisors that the disclosures are currently in the rule are so burdensome that they simply won't serve some of the middle-income investors. So I was hoping you could address that kind of cost-benefit trade-off around those disclosure requirements.
The best interest contract is our way of making sure, this is our Ronald Reagan provision in the rule, which is that we want to trust and verify. I have yet to meet somebody who's an advisor who hasn't told me that they put, or they think they put, their client's best interest first. And so what we're saying in this rule is we agree with you. That's the rule, and it's now enforceable. And the best interest contract is a way to make sure that you have a flexible roadmap for compliance and that it's enforceable. There's a number of disclosure requirements that we believe are very discreet and very targeted. You ought to know how much, what the fees are. I think that's a good idea so that you can make informed judgments because, an educated consumer is the best customer.
Would the consumer also have some basis to know whether those fees are high or low relative to the fees of others? Because, I mean, they might not know in seeing a fee.
And that's part of the education that they can absolutely get, because you want a comparison shop. You can do, there's a lot of modeling that you can do to figure out, well, what are the fees for a similar product elsewhere? And those are the types of things that this rule would permit. And actually, good practice would dictate. And so that's what we're trying to encourage.
In line with that education question in your last 30 seconds, there's a carve-out, as you know, for investment education in the rule. And I was hoping you could clarify about where that distinction is between advice and education.
Sure. One of the main things we did, and this was responsive to the feedback we got, is to clarify and really explain the line between education and advice, because we all agree that education is exceedingly important. And this rule establishes very broad parameters for education. So one of the most important things that you can do in education is talk about asset allocation. That's totally education. Nothing kicks in there. You should have some of your money in, equities, bonds, cash. That's education. Trade-offs between risk and reward are education. We had 1996 guidance that we put into the rule, the proposed rule, so that we're operationalizing something that the industry has been using for some time. We clarified that employers can provide advice, because employers are trusted advisors that people go to, and they're not generating a fee, so they're not fiduciaries. So we clarified that employers can provide advice. And we welcome your comments on whether the line is drawn in the right place or whether we should do something different.
Thank you, Mr. Secretary. I yield back.
I thank the gentleman for yielding. Next is Chairman Klein.
Thank you, Mr. Chairman. Thank you, Mr. Secretary, for being here. I think there is nobody, probably in this room and certainly up here, who doesn't agree that financial advisors ought to be acting in the best interest of their client. But the rule doesn't just simply say that. The rule is, in fact, quite complex. Dr. Rowe lifted up the book, and it's about this thick. And clearly, there is a lot of confusion. And so I'm not as thrilled as the ranking member that you've extended the comment period by 15 days. 45 would have been better. But the more discussion we have, I think the better, because right now I'm afraid the rule is going to prove to be pretty complex and in some cases maybe unworkable. Mr. Secretary, you said that you have had extensive outreach to the SEC, and since you're here under oath, I got to assume that that's a true statement, but it may depend upon what extensive and what outreach means. As you know, Mr. Secretary, going back to March 4th, the committee has asked for documents and communications to verify that substantive coordination has occurred between the Department of Labor and the Securities Exchange Commission. And after months of virtually no response, less than 48 hours before this hearing, the Department produced 827 pages of mostly scheduling emails, Outlook calendar items, and similar things. And this leads us to believe the Department has still not provided a complete response to our inquiry. So, here are the questions. Do these 827 pages represent the entirety of the written communications between DOL and the SEC?
Could you repeat your question, sir? I'm sorry.
Do these 827 pages that we just got from the Department represent the entirety of the written communications between DOL and the SEC on this fiduciary?
No, we've had an extensive conversation with your staff, and I'm a big believer in the importance of oversight, and I think you and I have had this conversation in many contexts, and we look forward to continuing to work with you. We also had agreed, we offered, I'm sure you're aware, to provide a briefing about the extent of the coordination. The materials were due the close of business yesterday. We provided them to you at the close of business Monday, so you would have an extra day to review them in preparation for today, and we will continue to work with you on this
and
issue.
We reviewed them quickly. So I'm not sure I still have the answer to the question. Is there more documentation that we have not yet received?
Yeah, we're still reviewing everything. This process has taken place over 5 years, and so we wanted to demonstrate our good faith in the work that we're doing, and so we turned over the 800
But
pages.
you're not claiming
and
executive privilege for not providing more documents. You just haven't found them yet? Or?
No, we're continuing to work with your staff, and I think we're working in a collaborative fashion. And we offered up a briefing to show the coordination. And with all due respect, the documents demonstrate, because all of the areas of discussion for a particular meeting are noted on the document. So the issue that was presented in the oversight request was, are we collaborating with the SEC? The documents that you have, I would respectfully assert, clearly demonstrate both a wide breadth and depth of collaboration with the SEC.
Is it all of the collaboration? That's what we're getting at. I mean, we'd like to have a log from you identifying responsive documents by date, author, subject line, recipients, and a summary of content. That's what we've asked for, and we haven't gotten that. We got 827 pages of stuff, and I appreciate getting the 827 pages, but as you know, Mr. Secretary, there's been a great deal of debate and conversation and unrest about who should be doing this in the first place, right? The SEC is charged under Dodd-Frank with some activities here. DOL is acting under ERISA for this, but we've been looking at coordination. We've had legislation in this body insisting that SEC act before DOL. That has not been signed by the President. It's not law. But we are very, very concerned as a body about what this coordination is between DOL and SEC. You've given us a bunch of stuff. We're looking for something a little bit more precise from that, and I hope you'll be able to provide that.
Well, I look forward to our staff oral briefing, because I think you'll get even more depth about what we have been doing. And again, the documents you have now and the proposed rule, you will see that virtually every section of the rule, there were conversations with us and the SEC. So if the question is, were we talking, the answer is a lot.
I guess I believe a lot. I'm looking for a little more precision. I yield back.
Thank the Chairman for yielding. Mr. Courtney, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Secretary,
Morning, Congressman.
For being here today. And you know, just at the outset, I would just sort of change maybe a little bit of the tone of the last exchange. And again, I have nothing but the highest regard for the chairman. But you know, this secretary, since he took over, in my opinion, has shown you know, a real willingness to work with the committee members on a whole host of issues. Mr. Klein and I raised the question of whether or not the Department of Labor's actions on the Office of Contract Compliance with hospitals was an overreach by the department. And to your credit, you ran the forensics and came back and actually terminated an enforcement action, which again was what generated our objection. The pension amendment to the Cromnibus, which the chairman of the subcommittee and the chairman of the full committee worked with your department to produce, you know, a change to the crisis that existed in defined benefits. Again, is another example of where this secretary has shown a willingness to work with this committee. And frankly, that has been a change since you took over. The last time the department came forward with a proposal on a fiduciary rule, it was a disaster. I mean, and I'm saying that as a, you know, as a Democrat, that it just was a fiasco. And you've already sort of alluded this morning to some of the changes that the department has implemented or proposed with the new proposed rule compared to the first fiduciary proposal. Again, you mentioned Mr. Guthrie's concern regarding ESOPs. That was deleted. The financial education piece, which frankly I personally think needs more work, and you've already said this morning you're willing to listen to people about ways to let the call centers do their jobs without sort of too much restriction. But the seller's exemption is an example. So maybe you could talk a little bit about, you know, where we are today versus where we were, whatever it was, 3 or 4 years ago when the department came out with its first set of rules.
I think we've come a long way, in short, and we've come a long way because I'm a big believer, and we had this chat yesterday, Mr. Chairman. When you're in the regulatory process, Number one, you've got to build a big table. You've got to make sure you're listening to every stakeholder. You've got to understand what the consequences of your proposed actions are, intended and unintended. And the best way to learn about the latter is to make sure you have a big table so that you can hear and learn from people who've been in it. And that's what we have done. And I'm heartened by the fact that this conversation has evolved from there really isn't a problem to address to a increasing recognition that we have to have one standard, and it needs to be a best interest standard because we don't save enough. And when a family works hard to save 50 or 100,000 or a few $100,000 in the case of the example I cited, we need to make sure that the advice they're getting is in their best interest. And that's what this is about. And the question of how to operationalize that, we asked literally dozens of questions in our proposed rule about precisely that. Because another principle of effective rulemaking is humility. We have ideas about how we think you can operationalize it, but we also recognize that so do others. You know, we've met with, and I've personally met with CEOs of Fidelity and others, and their input is invaluable to us, and we will continue to have those meetings. I've met with small businesses who are in this space who, frankly, they tell me with regularity, anyone who says that they're going to get out of the $11 trillion market, could you give them my email? Because I'm serving a lot of small savers, and I'm making good money using technology and looking out for their best interests. So there's a way to do it. And so I think we've improved the rule as a result of that listening, whether it's a more robust economic analysis, whether it's the ESOP issue that Congressman Guthrie addressed and we took it out, whether it's the best interest contract exemption, which is an effort to make sure that we have guardrails, the best interest rule, but we have flexibility and compliance. There's no bar on commissions. That was an issue that we heard and feedback we got, and we listened. And we clarified the line between education and advice. And as I said earlier, if people think that further clarification is necessary, give me chapter and verse, because we're all ears.
And, you know, we're going to obviously watch closely as the department continues its deliberations. One last, so when August rolls around and there's a revised, I guess, reg that comes out, there's an additional comment period after that as well. I mean, it doesn't just shut down at that point. Am I right about that?
Absolutely. We're having a public hearing in August. The comment period closes, and we have a public hearing, then we publish the transcript of that hearing, and we invite comment on that hearing. So we're going to, on that transcript. So we're going to end up having roughly 140 days of formal comment, and that's on top of the 2 years or so of outreach that we've done to date.
Okay. Thank you, gentlemen. Dr. Fox, you recognized.
Good morning. It's great to see you again.
Nice to see you. Thank you, Mr. Chairman, and thank you, Secretary Perez, for being here today. I've been listening to the comments made already, and having read a lot of the material about this with a great deal of interest. This, I will tell you, is not an area of expertise for me, but my husband and I discuss these things a lot. He generally handles our investments for us with a little bit of input from me. And I'm really interested in this issue of best interest contracts. And I know in many cases you can get advice that people think is in the best interest. I know my husband over the year has invested money in areas where he thought there'd be a great return. And yet something happens outside his ability to control it. It happens all the time in investments. You invest in one thing and the market's going up, and all of a sudden a new technology comes along or some substitute for that product, and your investment's not worth as much. You know, best interest, it seems to me, is in the eye of the beholder. But I want to ask you a quick question about this. If I talk to somebody, a financial professional, to help me open an IRA, why do I need to sign a contract before we can even have a conversation? Do you think that kind of requirement is going to intimidate the new investors that we need to get into the market and ultimately discourage them from saving? You know, signing a contract for the average person is a big deal.
The short answer is you don't have to sign a contract before you have a conversation, and we understand that the proposed rule, and we've, in part of our feedback that we've heard, this issue has come up with some frequency, and there have been concerns raised about the timing of when the contract requirement would go into place, and so your question is a perfect example of the issue of how do we operationalize this, because we have a shared goal in making sure that you can go out and get access to advice, shop around. I want to know what you're telling me, and I want to know what you're telling me, and I want to make an informed choice. Just like if I buy a car or I buy a refrigerator, I want to do some comparison shopping, and our goal is to make sure that that comparison shopping is facilitated. So we've heard that, and that's an issue that I'm confident are going to clarify, because we want to encourage shopping. We want to encourage informed consumers, and there's a lot that you can go to now and not have a contract. You can go and see somebody and talk about asset allocation. You know, what should my asset allocation be? You can look at interactive modeling and plug in a number of different assumptions, and you don't need a contract. That's all part of the shopping. The most important part I've learned from talking to folks in the industry about the conversations is the asset allocation conversation. You know, what's your risk tolerance threshold? What do you want to, and my wife and I have different risk tolerance thresholds in this, and we learned that during the course of meeting with our financial planner. And those are the things we want to facilitate, and those don't require a contract to have those conversations.
Well, one of the things it sounds to me like in terms of best interest is that this is going to be a full employment regulation for trial lawyers, because who decides what that best interest is going to have to ultimately be decided. One more question. Are you concerned at all that long-standing positive relationships between investors and advisors will be disrupted if they're forced to comply with a host of new mandates?
I am not concerned, because everybody that I have spoken to has said that I put my customers' best interest first. I haven't met anybody who says they haven't. And so what we're trying to do is operationalize and memorialize that. And as it relates to your question about
if they are already doing that, then why do we need to have a host of new rules and regulations?
Because we're trusting and verifying. Because I'm sure that when the TOEFLs went in, they thought they were getting advice that was in their best interest. But there is a structural problem here. And it's not about bad actors as much as it's about the fact that when you have a suitability standard, there are 5 different products that are suitable, but many of those products get you a better commission, and it's completely appropriate for you to steer someone to a product that gives you a better commission and does so at the expense of the consumer. I think that that's not in the best interest of the consumer, and so that's why we're trying to change it. And by the way, there's a substantial percentage of folks who are already fiduciaries. There's no evidence of a litigation boom with folks who are already fiduciaries. And we also have a provision in the rule, for your information, that allows a best interest contract to have a mandatory arbitration clause for individual claims. So a firm can put that in if they want, and it was designed to get at the concern that you addressed.
And gentlelady's time has expired. Mr. Pocan, you're recognized for 5 minutes.
Thank you very much, Mr. Chairman, and thank
Morning.
you, Secretary
Good to see you
Press.
again.
Good morning. Good to see you. Thanks for being here today, and I think we all agree that far too many people don't have enough money put aside to live comfortably in retirement. We need to do something to reverse this trend, and I really appreciate the work that you and your department are doing to ensure that Americans saving for retirement are able to receive investment advice that's in their best interest. I appreciate the open comment period and extension for the extra 15 days as well. And I think one of the things you've said over and over is in order for this rule to be successful, it must be workable. And I think that's where I just have a few issues that I'd like to bring up, just that people brought up to me that I think are something I hope you're looking at closely that maybe we can have some impact on. I would echo Ms. Fox's comment about this idea on signing the contract with advisor. I think it does need some clarity and clarification. While I completely disagree that the U.S. Chamber and FIB represent small business, I've been a small business owner for 28 years. I work in a business-to-business market. A fraction of 1% aren't members of those organizations. But you do know your thing well. If you're a chef, you may not be the best business person, but you certainly may not be your best retirement advisor, right? So, but it does have some questions about whether or not if you have to sign a contract right away, it's not just asset allocation. You might have some broader questions about, I want to do this in retirement. What should I be looking at? It's just a step further. But if you have to sign a contract for that, it is something that seems larger, I think, than just getting some initial advice. So, I guess I just like to associate myself with the comments on that, but just kind of really raise that issue, because I was talking to another Democrat on the floor yesterday, and this issue came up with that person as well. So I think more of us do look at this as something perhaps a little bigger, and we'd appreciate any consideration you could give to that.
Absolutely. I mean, you're addressing two issues, which is one is the line between education and advice, and we have a proposal out there. We think it's broad, but we're hearing feedback about how we can make it even clearer, and that feedback is really helpful. Secondly is the issue that Congresswoman Fox raised about when you execute that. And again, we've heard that, and that's why I keep coming back to why I love this process, because you have to have humility to understand that you've done your best to integrate the feedback you've gotten, and folks are going to help you make it better. And your question, Congresswoman Fox's question, other questions about the operational aspects of this are very important.
Yeah, and let me raise a couple more, if I could, just while I've
Sure.
got the time. Another one is there's been some concern over the data that's being collected as part of the rule, both from a substantive perspective and from the cybersecurity perspective, and you've probably heard some of these through the comment process. A few of the things were, like if you represent the investment fees versus the return can be misleading on the type of investment. Some investments are more like apples, some are more like oranges, but now we're going to try to combine them completely. There's been some conversations about the 6 years of sensitive data that we're going to collect, just making sure that that doesn't become something that is a collection of data that isn't as useful. And then there's a very specific about, if someone makes a good faith mistake versus something that instantly puts them into the excise tax area. Those are some of the things that came up, but also then I guess there's this question on the cybersecurity levels and whether DOL has the funding within the department to make sure they're going to have that. We know we're not great at appropriations around here. We want to make sure that that's all in place. So that's another level, I guess, I'd just like to raise real quickly. And I do have one more after that, too.
No, I mean, the good news is that we have heard from various stakeholders every one of those items. And again, they're all in the bucket of how do you operationalize this. Sure. One of our goals is transparency. When people know, right now the system is very opaque. You don't know what the precise fees are. Actually, people think it's free. And it's not free. And so that's why what we're trying to do here is to make sure that, by publishing what various fees are, then you can have, as I said before, a consumer reports of apples to apples comparisons that will help consumers make informed judgments. But all of the issues that you raise are absolutely things that we're thinking about.
Looking at, appreciate. In the last, because I know there's only seconds left, just real quickly on the 8-month thing, a few folks have said it's a little short. Can you just tell me how the 8-month idea for implementation came in mind and where we are in flexibility?
Well, that's another area where we're hearing a lot of feedback on, and there have been a number of suggestions that have been raised about phase-ins or how you can make sure that the rule is in effect. And so that's an area where we affirmatively ask for comment about that, and we're getting a fair amount of it. So I hope that we can have more conversation about that.
And we will relay some of these concerns directly to you. I just really appreciate the openness again. I think, every time you've come to this committee, you've been one of the most open folks that I've dealt with in my 2.5 years here, and thank you for
Well, it's an honor to be here, and I learn a lot. You make me smarter, all of you, so I appreciate it.
Thank you, gentlemen, for yielding. Mr. Walberg, you're recognized.
Thank you, Mr. Chairman. And
Good to see you again, Mr. Chairman.
Good to see you, and I hope you've got your wife a trip planned back to Michigan, right?
Absolutely.
Good.
UP.
Say yeah to the UP2A.
I don't have a Harley, though.
Well, I got to get one.
Yeah, I'll borrow yours.
You're welcome to do that. I heard you say nothing's free, and that's absolutely true. So in relationship to some costs, I'm concerned about the cost of this proposal, including the potential litigation and administrative costs that may go with it as a result. How many additional ERISA fiduciary lawsuits do you project will be filed annually if your proposal was finalized?
Well, again, there's a provision in the proposal that allows for mandatory arbitration clauses in the best interest contract. And that's a provision, actually, that we took from, I believe it was SIFMA or FINRA. And so in the area of trying to make sure we're harmonizing our rules with other rules, we put that in place because we recognize that that was a concern that people brought to our attention.
Any figure that you've considered on additional costs, a number of lawsuits that might be filed?
Well, we certainly have considered that. I would observe that we now have a controlled experiment going on because there's a substantial subset of people in this space who are already fiduciaries. So if your theory is correct that if you are operating under the best interest standard, you are more susceptible to litigation, that hasn't been borne out. There's no evidence that folks who are fiduciaries get sued more often. What the evidence shows is that when times are good, there tend to be less lawsuits against advisors, and when times are bad, there tend to be more lawsuits, regardless of whether you're a broker-dealer or whether you're a fiduciary.
Well, in order to make sure that that happens, how expensive will this proposal be for participants and IRA holders due to increased litigation risks and insurance costs?
Well, again, the premise of increased litigation risk, I mean, the evidence to date has shown that folks who are fiduciaries are not dealing with increased litigation risk. And everybody who has come in, including broker-dealers, and said, I like to think that I put my customer's best interest first. If they're in fact doing that, then they have little to worry about.
But they're worried about the complexity of the regulation that is expanding with this for all sorts of reasons, but there will be litigation costs. Is any figure out there that you've considered for the best interests? Because ultimately, won't these costs just be passed on to the investors?
Well, again, if there were evidence that fiduciaries were facing increased litigation costs, then that's something we would have flagged, and there's no evidence of that. So the notion that this is going to trigger a litigation bonanza when you have a mandatory arbitration clause in there, and when folks are already doing this, presumably, I respectfully take issue with the premise.
Well, I mean, always expanded regulation always adds some costs. So I guess I'll take your answer, but I'm concerned that we haven't assumed some greater costs and ultimately the impact upon the investor as well as the IRA holders, participants, et cetera. That would be a concern for me. And I guess I'd put it out still further. I guess I'd like to see the workup done to ultimately bring satisfaction to your mind that you seemed evidence, and that's fine, that this won't increase the costs, and ultimately those investors will experience paying for that cost. Let me jump onto one other thing, Mr.
There's a real
Secretary.
cost to the status quo, sir, as well. So, I mean,
Well,
I think
yeah,
when we have that.
I can understand that. Yesterday, I spent a significant amount of time in Oversight and Government Reform Committee on the issue of OPM and the data breach that went on there. We also had, recent months, VA in front of us as well. It was in a classified briefing there also, and it was unbelievable. The lack of preparation and expertise and ability to handle this with the OPM director, and ultimately, as you're probably aware, there's been a call for her resignation. In this issue, with the increased amount of data that you're going to be pulling in, what are you doing to make sure that that data is secure, and we have investors as well as the fiduciaries protected from a breach like that?
Well, if you look at our budget request for the fiscal 16 budget, we have a very robust request for IT. And it's not simply for this, but it's to make sure that our IT infrastructure is as impermeable as possible. And so I look forward to citing you during our budget deliberations about the need to have our IT request.
Yeah, it's not always money. It's preparation. I hope you're prepared to a great degree right now. I'd like to have some confidence in that.
Gentleman's time has expired. Mr. Sablon, you're recognized for 5 minutes.
Thank you very much, Mr. Chairman. And Mr. Secretary, it's always good talking to you and having conversations. I have some concerns in addressing how best do you operationalize this best interest standard in my district. Coming into this room, I thought we had 9 securities investment or advisors. Now I only count that we may have factually 4, 3 with each one of the banks and one with a gentleman that is a dealer or an agent for Fidelity. And so you can see how small the market is for us. And how do we do this? How do we bring this very well-intentioned best interest standard, which I like very much, without forcing these investors, these investment agents, or at least the one with Fidelity, to stop doing business in the Northern Marianas. We're forcing them to close shop because the cost of managing this, the business government oversight is going to grow higher for when his clients are not very large. And I'd like to maybe work with your office, and maybe if I understand it, maybe I'm sure you may have an answer for this, I don't know. But because we're so small, and I can tell you I could probably count in my 2 hands how many people have investments with firms that are housed in Honolulu probably, and they have the means to get up and fly there and be there. But for those the smallest investors, retirement savings investors, there's very little, and I'd like to see how would we manage this small accounts.
In the same way you would manage every account, and that is, small investors are the ones who are most vulnerable.
Very small.
Because, if you have a 1% loss, let's say you invested, I think it's $10,000, and you have it in for 35 years. If you, as a result of conflicted advice, see a 1% diminution in your return, that translates to almost $10,000 less. So it would be about $35,000 over time, and instead it's $25,000. And so I think that this rule is most designed for small investors.
Don't get me wrong. I think I like the rule. I think it's about time, but it's just that for places like as small as the Northern Marianas, where there's not very much money invested, it's just forcing these companies to decide to say, no, we'll just stop doing business there. Except for those 10 people I can count in my hands, everyone else would lose the chance towards accessing an investment, an agent, maybe not necessarily a broker, but an agent on how they could invest their retirement savings, aside from those who are employer-based.
Right. Well, one thing that has been really helpful, and I've certainly learned a lot about this industry over the course of the last 2 years, is that technology is a huge ally. It's a huge ally in rural America. It's a huge ally in the CNMI. And I mentioned in my opening remarks a company out of California, Wealthfront. They're a startup. They're 4 years in. They have now over about $2 billion in assets. They don't charge a fee for anyone who's under $10,000, and that's because they believe that they have a platform that enables them to significantly lower the fees, operate as a fiduciary, and do well by doing good. And so I think technology is a big ally for the residents of the CNMI,
Mr.
because
Secretary,
you can get exit.
And I don't doubt the well-intention of this rule. Let me just give you an example. Primerica, for example, has 21 investment accounts in the Northern Marianas. 21. I'm sure Fidelity has much more. Their ASC Trust does a larger business there, but Primerica is a huge company. They have 1.9 million investment accounts in the country. 21 of that is in the Northern Marianas. So we're very small. I'm just concerned that this new rule will force people to close shop, and people will have, instead of growing the market for us, it would have a negative effect. I'm not trying to stop your rule, and I probably won't, but just having this conversation, I hope that...
Well, I look forward to talking to you about the various vehicles that are accessible as we speak right now.
And thank you for your recent decision, Mr. Secretary, that this 5 years extension also works. But I appreciate that very much.
Okay. Thank you. Gentleman's time has expired. Mr. Guthrie, recognized for 5 minutes.
Thank you. Thank you, Mr. Secretary. Thanks for
Good to
being
see you,
here
Congressman.
again. And I know it's been mentioned a couple of times, us working together on sections of this proposed rule, and that was just a great process. want to reiterate, I think I talked about it before when we were in a public hearing, but I mentioned something in a hearing such as this. You said, let's get together and talk about it and follow through, and I think that it was a healthy change to the proposed rule, and we appreciate you doing that very much so, very much so. The one thing I just want to talk about is the president had a proposal of the MYRAs, and so there's a difference in MYRAs and IRAs, and I know it's Treasury, so it's not in your area, but just how your rule treat these differently. And I'll just start by asking, and I'll do this, MYRAs, there's a December 2014 letter from the Department of Treasury that exempts MYRA program from ERISA's fiduciary obligations. And the letter states that the exemption is granted for employers in part because, and I'll quote, some employers may also want to hold employee meetings to explain the MYRA program and encourage eligible employees to participate. Others may want to answer employees' inquiries about the MYRA program or refer them to Treasury's financial agent, unquote. And so this description does sound like the advice, or in many similar circumstances, that workers in my district rely upon. And since the letter acknowledges that workers need to get information and begin saving, and then exempts MYRAs from fiduciary liability, why are MYRAs different than IRAs? And is that in your area that you've looked at?
The MYRAs are not covered in this rule, and the Treasury Department controls all aspects of the MYRA rule. The whole
But in your proposal, how do you treat these MYRAs different from IRAs in your proposal?
MYRAs are not covered under our rule.
So you don't have the fiduciary.
So yeah, so that wouldn't kick in at all.
And the reason they're different, the reason you treat the MYRAs and IRAs differently?
Well, again, the MYRAs, as I understand it, and again, I'm outside my lane here, so I want to note that at the outset. The purpose of the MYRA was to encourage auto enrollment and in a different way, so that we can help more people who are trying to save. And when the Treasury Department put those in place, that as a result of the fact that it's kind of a startup, that was the decision that was made, and I think it makes sense. And so that's the situation there. I can get you more information because I don't want to misrepresent anything. And at the moment, what I do know is that the MYRA isn't covered here. What I don't know are the nuts and bolts of the
and I assume
MYRA.
it's because the MYRA is I guess where the Treasury Department seems to look at it is the MYRA is a government-run thing, so the government agent wouldn't be a bad actor or bad physical agent. I assume that's where they're coming from.
There's no referral fees for MYRAs, so you're not falling into any of the tests that would come under here.
That's fair.
So that's kind of a biggie.
Okay, so if an employer, well, you wouldn't really hit the employer in this, but if an employer is making a presentation to employees and said, here's MYRAs, here's IRAs, I mean, how does that handle in the proposed rule for fiduciary?
Sure. Well, an employer, if you're talking about an employer, I have 50 people in my business. I make, I have a grocery store. I think that was the one we met. And you're making presentations. You're not a fiduciary because you're not the one. And I think it was Congressman Pocan who said, I'm a good cook, but I'm not. This is not my bailiwick. So employers can provide those seminars and provide that advice, and they wouldn't fall within the rule because, again, they're not the ones who are giving it. Right, exactly.
Yeah.
So.
Okay, I guess my confusion is that the Treasury Department, I know it's not treats employers. It says employers will not be fiduciary, so it seems maybe it's probably different than your section, so it's probably, I think we've answered where I need to go with that. But again, appreciate the work that you've done on that and done with me and different members of the committee and people you've talked to on. And I think it has been an open process. I know there's some questions and more information to flow, but I'll tell you I had a good experience working with you, and I really appreciate it.
And anything else that comes up, feel free to give me a call.
Thanks.
Give me my cell.
Thank you, gentlemen, for yielding. Ms. Belamici, you're recognized for 5 minutes.
Thank you very much, Mr. Chairman. Thank you for holding this hearing on this really important topic. And we talk a lot about retirement security, and I have to tell you, I've had a lot of meetings about this issue. I'm particularly proud of my state. The legislature just passed the Oregon Retirement Security Bill. which is a voluntary plan to make an IRA available to all Oregonians without access to a retirement plan at their workplace, which, once again, our state is showing some leadership there on this really important issue. This is a fascinating but complex issue, and I'm fairly new to it, even though I did some work years ago as a lawyer in securities. So to try to understand the whole jurisdictional issue with when the Department of Labor is involved because it's ERISA and when state law is preempted and then the SEC involvement. And I'm glad you're working with the SEC and I appreciate your comments about telling the committee about all of those discussions and correspondence. So I wanted to just emphasize how important this is to our constituents, particularly middle and low income families in my district and all of our districts. It's important for them to have access to financial advice that they can trust. And again, I've had a lot of meetings about this. I've also heard from people in the industry who are very concerned about the implementation. We have made progress with the consensus now that the best interest is what the industry is saying they agree to, and it's the implementation that appears to be the issue. I've also heard from AARP, NAACP, National Council of LaRaza, all supporting the rule, and they've really made consumer rights a centerpiece of their advocacy. And I have a background in consumer protection, and I very much appreciate that. And to me, it seems like we have the same goal here, to make sure that the people who are getting advice that they can trust, and that it's in their best interest. So let's talk a little bit about some of the issues that have been raised, particularly, will you please clarify, because I heard over the past couple of years that it's going to be a big problem because we won't be able to sell any products on commission. That's been clarified, correct?
We won't be able to.
Sell products and get a commission.
Right. There was commissions are not banned under the rule.
Thank you. And then the information versus advice, and this has to do with the timing. Are you open to working on that and taking advice from people who are here? When does that contract, you talked a little bit about what if somebody calls in and can they get advice about the balance of investments? Let's talk about the timing, because that's been raised by industry as well.
Sure.
When does that contract need to be signed?
Right, and as I said, I think in response to a couple other questions, we want to make sure that we're facilitating advice and that conversation and the shopping that is critically important for consumers. And so that's an area that people have said, it doesn't feel clear enough to me when I have to sign the contract. And so we're working together to make it clear. And our goal is to make sure that we can facilitate the shopping and that we're talking about. And one thing I think that is clear in the rule is that there's a heck of a lot that you can do right now. So you can go to your advisor and he or she will tell you, what's your asset allocation and what's your risk tolerance threshold. And let's go online and we can plug in some assumptions, and you can see how if you go more equities versus bonds, and given your risk tolerance threshold, how it will affect you. All of these things are in the realm of education. We have a whole group of folks that do a steady diet of educating, because we want to, including seminars and things of that nature, because we recognize, again, as I've said, that an educated consumer is the best customer. At the same time, I'm confident that line is going to be drawn even sharper as a result of the input that we're getting right now, and we welcome that.
And I appreciate your involvement. And certainly the products are much more complex than when I think ERISA was in the mid-'70s. And it really is a different world out there, and it is critical. So I just want to emphasize that I appreciate your department's willingness to work with the industry, that your openness to hear the concerns, because again, we have the same goal. We want to make sure that people are getting advice that they can trust, that's in their best interest. And even though prevention is obviously ideal, your story that you told at the beginning about what happened to the family is, it's devastating what happened. I hope they had a remedy, and I hope that through this process we make sure that people who do end up in those situations have a remedy, so that they don't lose their life savings in their home. So again, thank you for your willingness to work with us, and appreciate your being here.
I look forward to it.
I yield back. Thank you, Mr. Chairman.
Thank you for yielding. Dr. Heck, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Secretary, for
Morning.
being here today. I think we've heard from everybody on the panel that no one would disagree of the importance of making sure that it's the best interest of the client who's seeking investment advice that comes first, just like the patient seeing their doctor or the client seeing their attorney. And again, it comes down to what my colleague just said about the implementation that seems to be under discussion, and making sure that the actions of a few don't impact on the practices of the many who are doing a good job in providing advice and education to their clients. I appreciated the anecdote you told about that couple that had problems with their investments. And I have a constituent, Janice, who called her insurance agent to see if he could help her with her recently deceased husband's 401k plan. They were retired, lived off of his pension as well as Social Security. From time to time, they'd take some money out of the 401k to supplement their income. Once her husband passed away, it became a beneficiary or a decedent 401k. So then when Janice tried to get some much-needed money from the plan, she was informed from the company that she was not eligible to withdraw the funds anymore because she was the beneficiary, and that she needed some help, and so understanding what her options were. So she called her agent, they discussed her needs, went over some of her options. She could take the funds out and pay taxes, continue to invest the dollars using a rollover, discussed the types of risks she was willing to take and the time frame they were working with to help her meet her needs. Ultimately, she was able to make a decision, rolled over approximately $21,000. There are many people like Janice who perhaps would not be able to find the information and knowledge to take care of these or many types of 401k rollovers or transactions that are in their best interest under the proposed rule. So if you could tell me, how does the rule actually protect the interest of individuals in this type of a situation?
Well, the rollover market is a huge market, and that is where you really need the right advice. And one thing that our rule does is clarify that employers are very much able to provide advice, including keep your 401k with us even after you leave, because we're talking about $1 trillion impact here. And so the standard, whether it's the rollover, whether it's how do I invest my 401k, is the same. You have to make sure you're looking out for your client's best interest.
And I would say that in this situation, this is the insurance agent that they've used their entire lives, that they did have trust in, and that this insurance agent did look out for their
I would
best
agree
interests,
from
right?
the circumstances that you've described. And again, that insurance agent sounds to me, at least from the limited facts that we know, has been already looking out for people's best interests, which is why compliance with something you're already doing is very readily attainable.
But you quoted, Mr. Vogel of Vanguard saying that they would basically look for a simple rule where clients come first. However, it doesn't appear that this rule is that simple, and so there are concerns amongst those individuals, like this insurance agent, that the proposed rule would actually limit their ability from providing these services to their long-term clients, because before they enter into this discussion, they're going to have a contract signed. They're going to have all this disclosure and disclose any potential fees that might be up front. I mean, if the same thing, if somebody was coming into my office that I had a long relationship with, and all of a sudden had to ask them to sign a disclaimer form and all these forms about potential fees and whatnot, why would I continue to use that individual as my advisor?
Well, I actually think that the implementation of this is a lot simpler, sir. And especially for those like the person you described who's already doing the job and is already abiding. Because folks who, whether it's a large firm, they already have in place policies and practices to make sure that they are mitigating conflicts. And so what we're saying now is, you have an obligation to do that. And so if they're already doing it, I think compliance is very workable.
You said several times that commissions aren't banned under the rule, but what are the restrictions, obstacles, or impediments to people providing products based on commission under the rule, if any?
Well, you have to make sure that you're putting your client's best interest first. And so, the situation that we deal with now is under the suitability framework, you may have 4 or 5 different options that you could that are suitable. And 2 of those options get you a significantly higher fee than the other 2 options. Well, if under a review of the circumstances that is reasonable, well, then you could do it. But chances are, the thing we're trying to do is correct the malalignment right now, because I want to make sure that when that person is making the decision, making the recommendations to me, that he or she is motivated by my best interest, as opposed to, I got 4 products here that are suitable, and I want you to take these 2 products, even if it gets you 1% less. I don't think that's right, and I think that has real cost for people. And we've prepared a toolkit for every member of Congress who wants to use it, so that they can help educate their constituents on the questions to ask, because this is a complicated world, and there's an inequality of information, and we want to empower consumers.
Time's expired, and Mr. Secretary, we don't want to become fiduciaries. Mr. Takano, you're recognized for 5 minutes.
You do pretty good at it, sir.
Thank you, Mr. Chairman. Welcome, Mr. Secretary. You mentioned a few times in your testimony that this is a simple proposal, and that allows for flexibility to reflect not only different business models, but also the innovation and technological advances some in the industry have made and continue to make. How do you envision the industry reacting in terms of product offerings and tech-based solutions, and how will this help small savers?
Well, let me take the example of Wealthfront. Wealthfront is a California-based company. They started roughly 3 years ago, and this is actually a letter from their CEO. They were built from the ground up to operate under a full fiduciary standard, despite serving small accounts and charging incredibly low fees. And they've now become a $2 billion asset management company. They don't charge management fees for accounts under $10,000 because we do not believe we need to make money on those in the beginning stages of saving and investing. We charge a fraction of what others charge for accounts over $10,000. And we know that there is a significant debate regarding ways to increase the protections and requirements around providing high-quality fiduciary service. We believe technology can dramatically aid in this front. Wealthfront is living proof that not only is it possible to provide fiduciary service at low cost to small investors nationwide, but that the market rewards these efforts. And we believe that technology can not only improve the quality of service provided to small investors, but also lower the barriers and costs that have limited their access in the past. Whether they're in California, they have a 50-state footprint. I don't know whether they're in the CNMI, but we have spoken to folks like Wealthfront. We've spoken to individual broker-dealers who are doing this on the front lines. I think technology is a real ally in this.
No, but has this been borne out? I mean, the technology. My concern is that some would say that what I've heard from people in the industry is that this rule might disincentivize people to help the small saver. And you're saying, well, technology will help offset that problem. And I'm just wondering, so Wealthfront's been able to build a market. They've been able to reach these small savers, the $10,000 a year savers. I'm just wondering whether or not if there's a test of this technology and. Go ahead. Yeah, go ahead.
Well, Wealthfront is not the only company that has figured out how technology can be your ally in helping to serve small, mid-sized, large-sized savers. I mean, technology is, I think, a linchpin to the innovation that's enabling more people to get access to advice. And that's why I think this is so important. An equally important fact here, and I think this is something that often gets overlooked, is a lot of people don't seek advice right now because they don't trust the advisors.
Okay.
And what we're trying to do by establishing a best interest rule is to help bridge the trust gap that currently exists. Because there's a lot of marketing out there, but sometimes the marketing and the reality, there's a little bit of a gulf between the two. And so when we can have increased trust by having a best interest standard, I think we help everybody, including small savers and large savers, get access.
I want to talk more from the point of view about the remedies for the investor or for the saver who thinks that they've been deceived or misled. Mm-hmm. At the end of the day, this rule is about guaranteeing Americans being able to make investments to retire comfortably. Can you tell me more about the process for investors if they feel they've been misled? You talked about the mandatory arbitration, but are there other remedies besides, arbitration may be a big part of it. Under what agency will they seek redress? Is it FINRA? Is it, who's the?
Well, we currently, our Employee Benefit Security Administration, EBSA, we have right now, a robust docket of enforcement cases. Bernie Madoff, we were part of that prosecution team. The Enron case, we were part of that effort. We have a steady diet of cases right now involving folks who have breached their fiduciary obligation to the detriment of individuals. And so that will continue. In this particular rulemaking, what we're trying to do is to create for the individual who has been wronged, potentially, a remedy through the best interest contract. The proposition that we're putting forth here is that you now have an enforceable contract, so that looking
Mr.
out
Secretary,
for
could
the
you
best
go ahead
interest
and
is what
wrap,
you do.
Mr. Secretary, could you wrap that up, because we have another panel?
Yep.
Also, that answer.
I'm done, sir.
Your time's expired.
Thank you, Mr. Chairman.
Mr. Allen, you're recognized.
Thank you, Mr.
Morning, sir.
Chairman, and thank you, Mr. Secretary. Get this mic right. Thank you for being here. Appreciate what you're doing. You talk about trust. I'm from the small business community myself, and about 30 years ago recommended that our folks participate in our 401k program, because I'm assuming that now makes me an investment advisor. I don't
Actually,
know.
it doesn't, sir.
It does?
No.
Okay. So, but anyway, recommended that. And the reason, and they asked me, well, why? And I said, well, frankly, I can't trust that Social Security is going to be here when you retire, based on, if you look at the actuarials and all that of Social Security. And so, yes, there is a trust problem out there, even with our own Social Security system. Exactly where is that going, and why aren't we working on that to try to fix that? And then we'll start giving people advice on how to deal with their own savings. But as far as the rule is concerned, obviously the investment business is just like my business. It's a relationship business. I've never had anybody that hired our company that went to the internet and said, well, I'm going to pick this company. They would actually check out exactly our reputation in the industry, plus the fact that, as I understand it from my friends in the investment business, it is a highly regulated industry already. And the fact that you had the Enrons and the others involved, part of that problem was the fact that it was accounting that should have been long ago discovered, as far as what, keep it two sets of books. But as far as trying to give investment advice, I don't quite understand how you're going to make this work. I mean, if you're, say you're dealing with my business right now, and you said, okay, we're going to implement this rule in your business, what would that look like?
Well, again, you're not a fiduciary, sir, because you're running a business.
Okay.
If somebody's giving you advice, and or there's somebody, your employee has $100,000 in their 401k, and they want to know how to invest it, and they go to this an advisor, and he or she gives that person advice, they simply have to look out for your best interest.
Okay.
Just like
Well, let me
when you
ask
go
you
to
this
the doctor, they have to look out for you.
I advised our folks to get involved in this 401k. Well, they were all tickled to death with it until 2008 and 2009, when the market took a tumble. And along with my investment advisor and myself, we suggested that, hey, America's going to come back. We need to have the confidence the country's going to come back. Now, I'm going to tell you what, they're a happy bunch right now. But what would it look like had that not happened? And here I am, and my investment advisor have given this advice. What does your rule do to me then?
Well, again, you have a duty to act with reasonableness and prudence. Just as a lawyer has a duty to look out for their client,
who
and a
determines
doctor
that?
has a duty to look out for her client.
Who determines
her
what is,
patient.
what is
These are-
fiduciary and prudent?
These are rules, reasonableness and acting with prudence. This is a construct that has been in place in the financial service industry for literally decades. Just as in other contexts, whether it's in the medical malpractice context, the duty of care, that is not a new concept. And so the notion that you have to look out for your customer's best interest is nothing new. And in fact, again, many people are already doing it
But don't
right
we
now.
already have those rules in place?
For some, but not for everyone, and that's why it's really confusing. Because if your constituents, when they go in, they think that everybody's looking out for them, and some have a legal obligation to do it, and some don't. That's a problem. That's confusing.
So how are you then going to mandate that people, I guess, check out their reputation of their investment advisor?
Well, no, what we're establishing is that the advisor that they seek out has an obligation to look out for their best interest. I cannot. We do a lot of education and outreach, and we hope that people will take the due diligence that they need. But what we're doing is making sure that the people they go in to see, we're taking out the uncertainty. Is this person looking out for my best interest, or does this person have other options? I don't think that's good for consumers. That's why we're doing this.
How can I trust you to do that?
The gentleman's time has expired.
Thank you, sir.
Ms. Wilson, you're recognized for 5 minutes.
Thank you, Mr. Chair. Secretary Perez, good to see you.
Great to see you.
I know that you are just as concerned as I am about the economically vulnerable. I represent one of the most economically depressed districts in the country, and these individuals I represent work extremely hard to provide for their families, but they struggle to make ends meet. The median household income in my district is $36,748 a year, 30% less than national average. South Florida also has a high cost of living, which is growing faster than the national average. These economic realities make it extremely difficult for my constituents to save at the levels that guarantees a secure retirement. In fact, on average, South Floridians have saved 20% less than in their 401k retirement accounts than the average American. For example, as a former educator, I worked with many teachers who lived on limited wages for years, but were given lump sums out of drop, sometimes as much as $500,000 to last them through retirement. They did not know what to do with all of that money. Because there is so little margin for error for those with limited savings, I want to be sure that they have access to sound advice from financial professionals trusted. My late husband was a financial advisor, and so to speak, back in the 80s, he sold tax-sheltered annuities to first-time people who had little money but were able to save. So I know there's going to be a rule. I know there's a proposed rule, and I'm hoping that this rule will make sure that when it's finalized, that people are not intimidated and will find the process access-friendly, that they will want to save and be given that sort of financial assistance. I want to thank you for responding to my letter and extending the comment period so stakeholders have the opportunity to submit comprehensive feedback. And under your leadership, I am confident that the department will continue to engage with stakeholders and the public and really look at the feedback that has been provided, because it is my understanding there has been a lot of feedback. I know how committed you are to making this rule work for all investors. I've heard your life story, and I know where you come from and how you have achieved. Can you speak more about the process that will ensure that all interested parties are heard in the formation of the final rule.
Certainly. We are in the middle of the formal comment period. One of the things that we don't generally do, but we did here, was to have a public hearing in August so that we can take additional comment on the rule. Following that public hearing, we will publish that transcript of that hearing and invite comment on that. We continue to do regular meetings, and I'm working not only with our team, but a lot of other folks have been involved in this effort. My colleague Jeff Zients at the White House has been very helpful, and our goal is to get it right. I think we can thread this needle. Your concerns that you've expressed about small savers, everybody, that's a concern we all share. And I actually think small savers can least afford the consequences of conflicted advice, and places like Wealthfront and others are serving every corner of this country now, and I look forward to learning from you and others about how we can use this as an opportunity to actually enhance access to services for everyone, but in particular for small savers, because I think we can. Because when we increase trust in the people from whom you're getting the advice, then we can increase access even greater.
Just one final comment. Sure. Technology is very intimidating to many people in our communities. It's something that we feel comfortable with because this is what we do. But people who don't have access to technology is intimidating. So let's be sure that we do not eliminate them from the equation because they're thrust into a pit that they don't quite understand. And make sure that when this rule is finished, they will have the same opportunities. I want to make sure that not only people with small amounts of money, but first-time investors, people who find themselves with drop $500,000 and not know what to do with it.
Okay,
These are the people I'm concerned about. Thank you.
Thank you. Gentlelady's time's expired. Mr. Messer, you recognize 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Secretary. You used the phrase small savers, first-time investors. I mean, that's what we're here to talk about today in this hearing. I represent a district full of those people. I represent 19 counties in East Central and Southeastern Indiana, working communities, people that work in agriculture and manufacturing. I'm also the product of a single-parent family. My mom just retired from the Delta Faucet factory there. She raised my brother and I on her own. She was somebody that couldn't really afford to save till she was well into her 40s and falls in the category here. I think one of the things we've got to remember as policymakers is we're not just accountable for our intentions, we're also accountable for our results. And we could bring forward rules with the best of intentions designed to protect people who, in the end, actually hurt the very people we're trying to protect. I think part of the challenge of threading the needle here that you've talked about is we've looked at other countries that have tried to do it and not had much success. And so we need to be careful that with the best of intentions of protecting these investors, we don't end up making their situation much worse. Of course, the best way to avoid that is by coordinating with others who have knowledge in the field. And I know Chairman Klein talked to you a little bit about your efforts to coordinate with the SEC. We're, of course, concerned that we haven't gotten the documentation from you that shows that coordination, also with the Department of Labor. I want to give you a quote and ask you to respond to it, Secretary Perez. In February of this year, SEC Commissioner Daniel Gallagher said the following: "The DOL has not formally engaged the commissioners, at least not this commissioner, on its fiduciary rulemaking process and the impact it may have on investors. And despite public reports of close coordination between the DOL and the SEC staff, I believe this coordination has been nothing more than a check-the-box exercise by the DOL, designed to legitimize the runaway train that is their fiduciary rulemaking." Secretary Perez, is this true?
I did not coordinate with that particular commissioner because I coordinated with Mary Jo White. She was the one commissioner because she is the chair. Just as when I coordinate with the EEOC, I go through the chair. And the documentation.
All this work's done at the chair level? All this work is done at the chair
No,
level? There's no staff coordination?
If I could finish, sir. The documents, the 800 pages of documents that we have provided demonstrate the dramatic and extensive coordination between our staffs. And you will look and see that there's page after page of documentation relating to meetings, relating to calls, relating to conversations about various aspects of the rule. I also traveled, sir, to the UK because I wanted to learn from their experience as well. And what we learned a lot about how the UK experience can inform our judgment. I've also spoken to the Consumer Protection.
Much of that documentation didn't include specifics about what was discussed in those meetings. Do you care, does the Department of Labor care about the inconsistency and confusion that could result from unharmonized rules of the road in this area?
Well, it's interesting that the former chair of the SEC is very supportive of the Department of Labor moving forward, and actually the current chair has indicated publicly that she thinks the best interest standard is the right way to go for the SEC regulatory agenda. So actually, she is saying conceptually that they should be doing the same thing that we are proposing in this rule.
Again, I think most folks, no one would quarrel with the intention of protecting these investors. The question is, will these rules actually make matters worse for those investors? You commented earlier about potential coordination with FINRA, and I want to give you another quote and give you the opportunity to respond. In March, at the 2015 Annual Financial Industry Regulatory Authority Conference, FINRA Chairman Rick Ketchum said, quote, "I fear that the uncertainty stemming from contractual analysis and the shortage of useful guidance will lead many firms to close their IRA businesses entirely or substantially constrain the clients that they will serve." Secretary Perez, to what extent did you coordinate with FINRA and other industry analysts, and why didn't you address their concerns?
Well, actually, what's interesting to note, if you look at the totality of Mr. Ketchum's comments, he says now that a best interest standard is indeed the right way to go, and I appreciate that. He says a requirement, and he talks about the solutions, requirements that firms carefully design structures and procedures to minimize conflicts. That's what we're trying to do in this rule. Adherence to existing security laws, more effective disclosures. So actually, there's a remarkable amount of overlap between what our rule says and what he stated. And we met with FINRA staff as recently as last week. So and we met with the Consumer Financial Protection Bureau. I personally traveled to England to meet with regulators over there and learn from them. We've done a lot of outreach, and we'll continue to because it's important in this process.
Thank you. Appreciate your time.
Thank you, gentlemen, for yielding. Mr. Jeffries, you're recognized for 5 minutes.
I thank the chairman for yielding, as well as for Secretary Perez for your presence and your leadership. The rule that we are discussing today was first put forth in 2010, is that correct?
Yes, that was 2010.
And then it was subsequently withdrawn, is that right?
It was withdrawn, and then we reproposed it earlier this year after a lengthy period of outreach.
And can you walk us through sort of the substantive changes that have been made
Sure.
from the withdrawal to the reinstitution of it?
Sure. One of the issues that was raised was we needed, there was a concern about having a more extensive economic analysis. So this rule contains a much more extensive economic analysis. There was a concern that Congressman Guthrie and others addressed about a provision we had in the 2010 rule about employee stock ownership plans. And the recommendation was to take that out, and we took that out. There was a concern about giving more flexible exemptions from the rule that you have to put your client's best interest first. And the best interest contract exemption is the attempt to do just that, so that we created guardrails but not straitjackets. And so that's a new feature of this rule. We clarified the line between education and advice, and we continue to take comment on that to see what the reaction is to where the line is drawn, and we've had some discussion about that today. So those are some examples of, I think, material changes from now as opposed to 2010.
Thanks. Now, there's been some discussion about ongoing engagement with the SEC.
Yes.
Has that engagement resulted in any substantive changes that have either been adopted or are under consideration?
Well, I think the SEC's, our interaction with them, especially I had interaction, I think it was 8 different times with Chair White. Our staffs have been together innumerable times, and I can certainly tell you with confidence that I think the proposal is a better proposal as a result of that interaction. It was a soup to nuts interaction, talking about so many aspects of this process.
Are there any specific concerns that the SEC raised that the Department of Labor has responded to in yielding the newly proposed rule?
We had a consistent back and forth, and again, we welcome that. And I had a consistent back and forth with Chair White. I didn't participate in the career level meetings, and those were the ones where there was a lot of good discussion and good feedback underway. And again, I think as a result of that feedback, you'll see there are provisions in the rule that I think are very, very informed by our judgments and our feedback, not only from them, but from the Consumer Financial Protection Bureau, from members of Congress, from consumer groups, from industry stakeholders. Everybody has an expertise to bring to bear in this, and our goal was to make sure we built a big table so that we could take all that advice to bear.
Now, is my understanding correct, based on your earlier testimony, that the CEO of Bank of America supports the proposed rule?
Well, what I said before was that what Brian Moynihan said was, we believe that doing what is in the best interest for your customers is absolutely the right thing to do. We have been clear that we see the industry moving, and we expect to help it move there. And so, the fundamental tenet of this rule, which is that you have to act in your client's best interest, is a tenet that has increasing support. Now, we're getting a lot of feedback from everyone, including but not limited to B of A, about the questions of operationalizing that and making sure we give it good meaning and that we address the issues of unintended consequences, things of that nature. But a really important part of this rule, a linchpin, if you will, is making sure that when you walk in and your constituents walk in to get advice, that they don't have to wonder whether that person is operating under one standard, a higher standard, or a lower standard, or maybe both. That's
Lastly,
confusing.
as my time is expiring, Mr. Secretary, how would you define a small investor in terms of is there a threshold, is there an amount of the investment, in terms of who are the individuals that could potentially benefit or could potentially be harmed by this approach, depending on what stakeholder you're listening to?
I think any investor who is going to have greater assurance that his or her person giving the advice is looking out for their best interest is going to benefit. And small, medium, large is kind of in the eye of the beholder. I've spoken to people who have clients that have $5,000, $10,000 in their portfolio. I've spoken to people with clients who have millions, and the rule is the same.
Gentleman's time has expired. Mr. Rothman, you're recognized for 5 minutes.
Thank you very much. My first question is with regard to fraternal organizations. Okay, fraternal organizations. Okay, fraternal organizations, first of all, are a little bit different breed because they have certain requirements under the IRS code, so they're kind of highly regulated by another agency, and for that, they also disproportionately, I think, take care of smaller investors. Maybe a lot of the IRAs are under $25,000, which is kind of a unique thing as well. And I think the combination of the fact that they have their own rules under the IRS and they have a lot of smaller investors are going to make this much more difficult for them to implement. Have you had discussions with these fraternal organizations, and are you prepared to have further discussions and maybe make changes so that these large organizations, which have so many investors in them, including myself, are continue to be able to thrive?
The short answer is we have had discussions with fraternal organizations. I think that's 501c8 of the Internal Revenue Code. And what we did in the rule, we ask a number of questions in the rule. And one of the questions that we ask is, do you have a unique set of circumstances that dictate that we should be taking a different approach as it relates to your circumstance? And this is an example. The meetings that have been taking place with fraternal organizations, that's the issue that we invited, and I welcome that. And we're having that discussion as we speak, and I look forward to your more specific observations about what you think should be done
Well,
as it
if you
relates
want
to
to
them.
meet in my office, I mean, I think right now, these large organizations with, I'm sure, millions of investors and many employees are really jeopardized. And that's a problem you have whenever you have some massive new rule, some one-size-fits-all rule. Sometimes you have people who don't fit that rule. And I am told, and it makes sense to me, that this would be devastating for these large organizations. Now, do you plan on making further changes before this rule would be implemented, or meeting with them again?
Again, we've already met. We'll continue to meet. And the purpose of meeting with people is to learn from people and figure out what changes are called for in a final rule. And as you've seen, the current proposal is far different from the 2010 proposal, and that's because we sat down, we built a large table, and we listened to folks. And we're continuing that process now. And so I appreciate the fact that folks have been taking us up on it. And anyone who comes to see you to say, I have a challenge, I would encourage you to send them our way, because we want to listen and learn.
Good, that'll be good. Next quick question. And I'm kind of jumping ahead here to the testimony of somebody that's going to be speaking later. It just kind of jumps out at me that apparently there's going to be a public database of compensation, total compensation given to employees of firms or that sort of thing. Is that true?
No, there's a transparency provision that is designed to get at the following problem. Compensation schemes are very opaque right now because you can legally get your fees from different sources in this. And what we want to make sure is when consumers are making judgments, they understand how much things cost, and so they can make an informed judgment as to whether this is a good deal for me.
Right. Just what kind of jumped out at me was, if I'm making $40,000 a year, if I'm making $90,000 a year, if I'm making $150,000 a year, all of a sudden, am I reading this right? That all of a sudden that's going to be public knowledge? I mean, maybe it should be. I'm just saying it's kind of a.
Well, the database isn't public. I think the one you're referring to is not a public database.
It says a website, no?
But it's not a public website.
Okay. Final question I have for you. People are permitted to earn reasonable compensation, and nobody should be able to earn unreasonable compensation, of course. But who defines that? I mean, what's the definition of reasonable compensation?
Well, again, these are definitions that have been part of the practice for literally decades. Acting with reasonableness and prudence under the circumstances. Everything is a case-specific determination, but these principles of acting prudently and looking out for your consumer, your customer's best interests have been well established. This is not something that's drawn out of thin air.
The gentleman's time has expired.
Thank you.
Mr. Anahosa, you're recognized for 5 minutes.
Thank you, Chairman Rowe. Can you hear me? I want to thank you and Ranking Member Polis for holding this important hearing, but I especially want to thank Secretary Pettis for being here and for the work you and your staff have been doing in the conflicts of interest rule re-proposal. Subcommittee Chairman Rowe and I co-chair a Senior Citizens Caucus, which covers financial literacy to help these senior citizens make good financial choices in their retirement years. So this rule that we're discussing is of great interest to both of us as chairs and to many members on both sides of the aisle, as I've heard the questions. I think that we want to ensure access to advice at a very low administrative cost as federal employees, which number probably several million, get 0.25% administrative costs for investing our thrift savings program investment and retirement portfolio. I think that I really paid attention to Mr. Congressman Rick Allen from Georgia giving us his example of investors losing a large amount back in December 2007 and the following year, 2008, which is the time of the worst recession in 50 years. And I enjoyed listening to how you handled that, and many of us did the same. We stayed in the market, but I will say to you, Mr. Secretary, that sometimes older men and women have good advice, simple. I remember hearing one tell me, just remember that you buy low and sell high. And so I did that. On January, the first week of January of 2008, I called and I changed my particular investment portfolio into treasuries, 100%. And that's the best thing that I could have done.
Why didn't you call me, sir? I could have followed suit.
I can only say that this hearing today has been very, very interesting, and I want to ask a question or two before my time gets away. I read Mr. Haley's written testimony, which reads, he claims the best interest contract is problematic and that the rule is unworkable as drafted. Moreover, that small businesses and lower and middle income investors will be harmed the most. Mr. Secretary, in your view, do you believe this to be the case?
I don't, for all the reasons I've discussed. Small investors are the ones who can least afford the consequences of conflicted advice.
I agree with you 100%.
And
let me ask you another question, because we agree on many things. I am most interested in the proposed rules' impact on the small savers and those middle-class workers who do not have hundreds of thousands of dollars to invest, but who are interested in ensuring what they do have to invest, they want it to grow. And I want their savings to do that too. Is there any reason that they should expect to pay more for the administrative services they currently receive, as in examples that I heard that are up to 4% of the investment?
Well, I think it's not going to be in your best interest. I'd rather have more money in my pocket when I can get a better return. And the challenge right now is that the system is misaligned. And too often, advice is motivated by the fees it generates for the person giving the advice, as opposed to what's in the best interest of the customer.
Well, in my opening remarks, I said that we federal employees, and we number in the millions, only pay 1/4% for advice and for them to do the investments for us. And that 4%, as you said, is way, way too high. So I'll ask one last question before my time goes up. Would you say this rule can help address the challenges and retirement savings gap many Hispanic and minorities face when it comes to saving for retirement? Because they, according to the materials I've read, are amongst the highest, in like 40%, that have very little in assets to protect and invest.
Mr. Secretary, I'm going to have to ask you to hold that thought.
I can give one sentence.
Sorry that the time has expired. Mr. Carter, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Secretary, thank you for being here. Mr. Secretary, I have to be quite honest. I'm going to preface my questions by saying that I'm deeply disturbed by this and not in favor of this at all. I'll just go ahead and tell you. But let me ask you something. The premise for your action here seems to be that you're saying that conflicts of interest have resulted in higher fees for those that are in IRAs than are in 401ks. And that it's because of these conflicts of interest that it's resulted in the higher fees. Yet the Investment Company Institute has discredited that number and said that that's not true. Said that it has only increased at 0.16%, and that indeed can be attributed to the fact that they get more advice and that they get a higher level of service. So if your premise is that the conflicts of interest are the reason why we need to have contracts, why, and yet we have the Investment Company Institute who disputes that, what's your premise then?
Well, sir, we have many people in the industry who are saying that we need to have a best interest standard because the system is misaligned. When I go in to see my doctor, I know that he or she is looking out for my best interest. I got cancer. You're going to tell me what's best for me. You're not going to tell me what's suitable for me. And when I go into a doctor or when I go into a financial advisor and they're telling me what's suitable, well, what that means is that there may be 4 or 5 products that are suitable.
But aren't you kind of painting it with a broad brush here by saying that all investment bankers or all investment consultants don't have your best interests at hand?
Well, with all due respect, sir, in my opening statement, I explicitly said that most of the people in this business are trying to do the right thing. There are a few bad apples. What we have is a structural systems problem. People are rational. They respond to the incentives that are there. And it is perfectly legal right now to steer someone to a product that maximizes your return as the broker-dealer at the expense of the return of the individual investor. And that's what we're trying to change. We're trying to change this malalignment and make sure that every time I walk in and every time your constituent walks in, they can have confidence
Mr. Secretary,
that their advisor is going to do that.
wouldn't you agree that this is already an over-regulated field? That we have probably more regulations in this area than we have in any other area?
The TOEFLs couldn't.
And what you're suggesting is that more regulation will actually solve the problem.
The TOEFL family couldn't disagree with you more, sir, because the TOEFL family lost $50,000 as a result.
I understand that, but there have been
advice.
many families, and I'm sure you could get many situations and many examples where just the opposite has happened, where you've had advice given by advisors that has resulted in people being able to live a better retirement. Because, let me give you an example. I'm a small business owner. I've owned a small business for over 27 years now. When I first went into business, I started a 401k within my business. And I will say that it is one of the best things I ever did. A great program. And it's one of the things that I'm most proud of in my business, the fact that I can offer my employees that kind of program where they can invest, I can help match, we have profit sharing within that, they can borrow from it, and they do that. In fact, just this past week I had an employee who is actually borrowing from her 401k in order to pay medical bills that she is saddled with right now. So that is something that has worked out well, and I don't think that I would have done it had I had to enter into a contract with a financial advisor. I mean, I'm a pharmacist, and my patients don't have to sign a contract with me before I make recommendations for them. I'm not seeing where more government regulation is going to solve this problem. This seems to me to be a solution in search of a problem.
Well, sir, one thing I can wholeheartedly agree with you on is we will not agree on this.
Well, and you're absolutely right, because the fact is that I'm a free market person, and the fact is that I believe the free market works. My example, unlike what you might see, is a better example and an example of where it has worked, and it's worked well. And I'm very proud that I was able to offer that to my employees. They're very happy with it. I'm very happy with it. It provides all of us with a good retirement. And it did not come about because we had a contract with a financial advisor. Mr. Chairman, I yield back.
Gentleman's time's expired. Mr. Scott, you recognized for 5 minutes.
Thank you. Mr. Secretary, what is wrong with the free market just taking place and people being able to get what they can out of transactions?
Well, the free market didn't quite work for the TOEFL family, Congressman, and it didn't work because the system right now creates incentives, and it's perfectly legal for people to give advice that is motivated not by a concern, first and foremost, for your client's best interest, but by the fee structures. That's what we're trying to change.
If you had the free market, would there be any limit to what an unscrupulous advisor could get out of a client?
I think
if
we
the
would
client
have.
agreed to it?
I fear we would have more TOEFLs.
We're talking about pension funds. This rule only affects pension funds, is that right?
Well, it affects 401ks, it affects IRAs, it affects rollovers. It's about it's trillions of dollars is what we're talking about right now.
Tax advantaged accounts.
Correct.
We made these tax advantaged for a reason. Is there any reason that they should be treated more preciously than other funds that an investor may have?
Well, Congress made a judgment to give tax preferred treatment. And the purpose of, and that was a good judgment. That was a sound judgment. I don't think Congress made a judgment to give tax preferred treatment so that people who are then trying to make sure they have a healthy retirement, like the TOEFLs, then get themselves into the circumstances they found themselves in, which were totally preventable.
Now, we've heard about this industry being highly regulated. Did I understand you to say that if an investment advisor knows that another product may not be as good, but he can make more money on the other product, that he could sell that product to the client knowing that he's going to make more and the client's going to make less?
There's a suitability threshold that must be surmounted, but within that suitability threshold, you can have a number of products that have different commission or other fee structures for the person selling that. And the current system has no, does not prevent you from taking advantage of that incentive. And I think that's wrong, and that's what we're trying to change.
So if you're selling essentially a S&P 500 fund, and you know that the client could get it at a much lower price, there's nothing wrong in the present system in selling the mutual fund that pays the broker more money,
well, you
right out of the client's pocket.
You would want to look at not simply price, but return and things of that nature.
S&P
But you couldn't.
All of them going to do essentially the same.
The premise of your question, yes. I mean, assuming all things are equal, then that's the challenge that we're trying to address in this rule, is to make sure that we're putting your client's best interest first.
Now, how would a client know that they're getting ripped off like this without the rule?
That's a huge part of the challenge that we confront, because people are unaware. You don't know what you don't know. There's a very significant inequality of information here, and that's why this rule is necessary.
And that's why the client went to the advisor in the first place, to try to get some good advice.
Well, and they assumed that they were trustworthy. They read the marketing materials, and in fact, most are very trustworthy. But we're trying to do the Ronald Reagan trust but verify by having an enforceable contract.
But what level of sophistication are we talking about? People coming to an advisor looking for the right advice. How vulnerable are many of the people to getting ripped off?
Well, if you're like me, you don't know a heck of a lot about it. And I feel like I'm a fairly educated person, but I also, when I go to my financial advisor, I feel the same way as when I go to my mechanic. These are two areas where I know very little about, and I want to trust somebody else. And I want to make sure that trust is not misplaced.
Thank you, Mr. Chairman.
Thank you, gentlemen, for yielding. Thank you, Mr. Secretary. And before I close, just a couple of comments. I think we all agree with the best interest standards. I think everyone in the industry does, and everyone here today does. I don't think there's any issue about that. We also, the GAO report clearly showed that we have 29% of people in this country that have saved no money over 55. 23%, that's over half the nation, just have a small defined benefit and no savings. So we have a huge crisis. I don't think we need to make it harder. We need to make it easier for people to invest money. 45% of people in a TSP have the default. That's just the Treasury, and that's a very poor return. And you gave an example of a very unfortunate investment advice. Well, let me just share with you, Mr. Carter shared with you some. I can share with you many of them. A $78,000 investment in November of 1996 that went through the worst economic recession since the Depression. that in March of 2015, in a broker-dealer fee-based plan, was $362,000 left alone and invested with that same advice. So there are great stories out there also. And I think the question I'd have to ask is at the end, and you can think about, does this rule make it easier and for businesses to do this? Does it make it cost less? Can you make a commitment basically today that no one will lose their financial advisor? I mean, it's like the president said, if you like your doctor, you can keep it, but it didn't work out that way. In reality, when all the rules of the Affordable Care Act came in, will people not pay higher costs if a low-income person, it was very much of Ms. Wilson and others over here, are worried about the small investor? Will they be forced into a plan where 1% of $10,000, maybe 3/4% that I might pay on a managed account, are they going to have to pay that? So those are things I think we need to think about in the rulemaking process. And I want to thank you for being here, been very forthright today, and look, for a large family like yours with 5 in the family, 4 out of 5 turning out okay wasn't bad. So
that's pretty good. I agree.
So anyway, thanks very much, Mr. Secretary.
Sir, and I
Thank
always
you.
appreciate your courtesy.
Thank you so much. I'd like to have it's now my pleasure to invite our second panel to the dais, please.
Mr. Chairman, how are you? Nice to see you. Thank you. Chairman, Dennis Keller, nice to see you. Nice to meet you. I think we all understand it anyway, so it's like, don't get too comfortable, right?
It is now my pleasure to introduce our distinguished panel of witnesses for the second panel. Our first witness is Mr. Kent Mason, is a partner of Davis & Harmon, LLP, specializing in employee benefit matters. Prior to entering private practice, Mr. Mason held positions at the Joint Committee on Taxation and in the Treasury Department. He represents a broad cross-section of firms that offer and service employee benefit plans. Mr. Jack Haley is the Executive Vice President, Professional Services Group with Fidelity Investments. He has been with the company more than 30 years and currently serves on its executive board. Mr. Haley also currently serves as President and Chairman of the Board of Directors of Fidelity Management Trust Company. Mr. Dennis Kelleher is the President and Chief Executive Officer of Better Markets, Inc., a nonprofit organization that promotes the public interest in the capital and commodity markets. Previously, he has held several senior staff positions in the United States Senate and was a partner with the law firm of Skadden, Arps, Slate, Mager, and Fromm. Dr. Brian Reed is a chief economist at the Investment Company Institute, where he leads the Institute's research departments. Previously, Dr. Reed was a staff economist at Monetary Affairs Division of the Federal Reserve Board. Lastly, Mr. Dean Harmon is the founder and managing director of Harmon Wealth Management. He has over 17 years of experience working with individuals and families with planning and investment management. Mr. Harmon is a member of the board of directors of the Financial Services Institute. Mr. Mason, you're recognized for, and well, before I start, let me swear you in. If you all would, I'll ask the witnesses, please stand and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative, and you may take your seat. Before I recognize you to provide your testimony, let me briefly explain our lighting system. You have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time is expired, the light will turn red. At that point, I'll ask you to wrap up your remarks as best as you're able, and members will each have 5 minutes to ask a question. Mr. Mason, you're recognized for 5 minutes.
Thank you, Mr. Chairman. My name is Kent Mason.
I'm a partner with the law firm of Davis & Harmon, and I've worked in the employee benefits area for over 30 years. I want to thank the subcommittee for inviting me here to testify. I'm testifying today on my own behalf based on extensive discussions with plan sponsors as well as numerous financial institutions. Before turning to sort of the meat of my testimony, I want to mention 3 key points. And this first one echoes, I think, what you've said here, Mr. Chairman. The industry is absolutely fine with the best interest standard and has been for the past 4.5 years. You know, I mean, every time somebody says, well, no, there's concern from the industry, there hasn't been for 4.5 years. The concern has always related to the prohibited transaction rules. And these are the rules that make certain business models effectively illegal, such as the brokerage model. And those are the business models that provide assistance to low and middle income individuals and to small businesses. So that has been the issue for 4.5 years, and it's really not been addressed. The second point I want to hit is, even aside from the advice issue, we've had a lot of talk this morning about education. I just want to make one thing clear. The 2015 proposal significantly cuts back on permissible financial investment education. 2010 preserved financial education. 2015 explicitly cuts back permissible financial education. And that leads to the third point I want to hit before going to the meat of my testimony, which is, I think there's been a perception that this has been an evolution, that we took the 2010 proposal and we sort of updated it and made some progress, and we've got to 2015 and we're going to make some more progress. In actuality, there is a growing consensus among the industry that the 2015 proposal, as this is detailed in my written testimony, is actually much worse and much less workable than the 2010 proposal. So the trend line is going in a disturbing direction. In my meat of my testimony, I'd like to focus on 2 points: the effect of the reproposal on small accounts, small IRA accounts, and the critical need for legislation. Small accounts. There are 2 ways that IRA accounts can get assistance. One is the brokerage model, with commissions paid and payments from the mutual funds, such as marketing fees or record-keeping fees. As explained in detail in my written testimony, as a practical matter, the proposal makes the brokerage model illegal. So that model is really off the table. The second way to provide investment assistance is through something called an advisory model. Now, if somebody comes to me and says, I want to enter into an advisory relationship, what I owe that person is 24/7, 365 fiduciary responsibility. I owe them around-the-clock fiduciary responsibility. And in exchange for that, what I get is a flat fee, like 1% of pay. And that 1% of pay, the problem is that structure won't work for small accounts. Because if somebody comes to me with a $4,000 IRA, I can't provide around-the-clock 365-day service for $40 for 1% of pay. So that's not available to small accounts. Oliver Wyman found that because of this analysis, that just under their study sample, over 7 million IRAs would lose access to an investment professional. And as many as 360,000 fewer IRAs would be opened every year. And a lot of the reaction to this has been, well, industry will never walk away. They'll never walk away from this market. But that's exactly what happened in the United Kingdom under almost an identical rule. The industry went away from small accounts in droves. And then the question is, when would this happen? Under the current structure, under the current timetable for the Department of Labor, millions of small accounts would be told in the fall of 2016 that their investment advisor can no longer serve them because of new government regulations. October, September of 2016. That's the message that would be delivered. And just to wrap up, what we need here is bipartisan legislation that establishes a workable, a best interest standard with workable rules, not the unworkable rules that are in this proposal.
Mr. Mason, Mr. Taylor, you recognize for 5 minutes.
Chairman Rowe, Ranking Member, members of the subcommittee.
Could you turn on your mic?
Sorry about that. Thank you for the opportunity to testify. My name is Jack Haley. I'm an Executive Vice President at Fidelity Investments. I oversee a team of investment professionals dedicated to helping employer clients and their workers access a wide variety of high-quality investment products and services to meet their investing needs. At Fidelity, we have the privilege of helping more than 25 million people save for their financial goals and serving more than 14,000 workplace clients, including 8,000 small businesses who offer retirement savings benefits to their workers. From our roots as a small mutual fund company, Fidelity has grown into a diversified financial services leader. Fidelity takes seriously the responsibility of helping employers set up and offer competitive retirement savings plans. I appreciate the opportunity to share our experiences helping small businesses and express our concerns about the Labor Department's proposal. First, I want to answer a call from the Department of Labor by stating directly up front, Fidelity acts in the best interests of its clients and investors. We support a best interest fiduciary standard, but the details matter. We are proud of the services, products, and choices we provide our customers, but we fear that this proposed regulation will severely restrict our ability to continue providing this assistance to small business and workers. While the framework of the proposal would theoretically allow service models to remain when acting in the best interest of customers, its so-called best interest contract exemption contains so many problematic conditions that the rule is unworkable as drafted. Labor's proposal effectively prohibits access to affordable financial help, even when it's in the interest of the investor. We believe a balanced approach where savers can be protected by the best interest standard and continue to have access and choice in their retirement products, services, and providers. We look forward to continuing to work with the members of Congress and the administration to ensure that this balance is reached. Small businesses remain the lifeblood of our economy. These hardworking entrepreneurs and business people bring significant expertise and passion to their work. We see their desire to offer competitive, high-quality retirement savings benefits to attract and keep a highly skilled workforce. Not surprisingly, with all they have to do to manage their businesses, there is little time, expertise, or desire to manage their retirement savings plans. That is why small businesses turn to us. We provide a range of critical services, from helping companies understand and select the right savings vehicles to providing all of the critical functions to keep a plan running smoothly, including record keeping, compliance testing and reporting, selection and ongoing monitoring of investments, and most importantly, education and guidance for their employees. Unfortunately, the DOL proposal would specifically prohibit service providers from assisting small businesses. The result would have a devastating impact on retirement coverage and savings for millions of workers employed by small businesses across the country. I reiterate, we support a best interest fiduciary standard, but without exemptive relief from ERISA's strict rules, Fidelity would be prohibited from providing critical services to small business clients, even when we provide help that's in the best interest. Just as important as our small business services is the critical education and guidance we provide to their employees. The proposed rule jeopardizes many of the ordinary, everyday conversations we have with job changers, even if the conversation is merely educational, where we do not discuss investments or advice. We are also able to help workers prepare for retirement by discussing potential product and service offerings with them. The proposal would require workers to sign a contract before a conversation would even occur. Each customer would have to have a contract with each of our phone reps, which number in the thousands, in order to get answers to basic questions. In addition to this new contract, the rules also include burdensome, confusing disclosure requirements that do not actually disclose potential conflicts. These requirements are not in anyone's best interest and must be addressed. These are just a few examples of the critical services we provide to small businesses and employees, and how the proposal would harm the very people the rule intends to protect. We believe a balanced approach, providing investors with fiduciary best interest protections, retaining existing service models, is achievable. We look forward to working with you to make the necessary changes to allow individual retirement savers and businesses offering retirement plans to have choice and access to the products and services they need. Let me close by stating unequivocally that we support a best interest fiduciary standard crafted in a way that allows workers choice and access to the services they need and desire. Thank you, and I'm happy to take questions.
Thank you, Mr. Haley. Mr. Kelleher, you're recognized for 5 minutes.
Chairman Rowe and members of the subcommittee, thank you for the invitation to Better Markets to testify today. I'd like to discuss just a few points that are detailed in my written testimony. First, it is unacceptable that brokers and others today are allowed to put their economic interest above their client's best interest. That conflict of interest is costing Americans saving for retirement tens of billions of dollars a year every year. Make no mistake about it. That is what is at stake here, and ending that is what the Department of Labor's proposed rule is all about. Today, tens of millions of hardworking Americans are struggling to make ends meet, provide for their families, and save a little for retirement. Figuring out how to invest those retirement savings forces many to seek investment advice from a broker. But that broker can put his or her economic interest above the client's best interest. What does that mean? If there are two similar investments, but one pays the broker 5% and the other pays the broker 1%, then it's perfectly legal today for that broker to advise the client to invest in the product that will cost his client 5 times what it should be. Making matters worse, often the products that pay the brokers more don't perform as well as similar products. That means not only has the client paid 5 times more up front, but he or she is also stuck with a product that doesn't perform as well over time. The client is doubly victimized. As famed Vanguard founder Jack Bogle has called it, they're victimized by the tyranny of compounding cost. That's what is happening every day in this country. It's costing Americans tens of billions of hard-earned dollars. For example, the Department of Labor has detailed that these conflicts in the IRA arena only are costing savers as much as $430 billion over 10 years, or $43 billion a year. Second, the rule governing retirement investment advice is 40 years old. It is outdated and incapable of properly protecting workers and retirees in light of the dramatic and far-reaching changes in the way Americans now have to save for retirement. When this rule was written 40 years ago, almost all retirement savings were in defined benefit plans, which were run by employers and managed by investment professionals with fiduciary duties. 40 years ago, 401ks did not exist, and IRAs had just been created. Today, 40 years later, 401ks have gone from $0 to $4.6 trillion, and IRAs have gone from $3 billion to $7.4 trillion. By 2012, 90 million Americans, more than 2/3 of all workers with retirement plans, had individual contribution plans. They are all forced to figure out their own retirement investments. This is a monumental and mind-boggling shift from 40 years ago, and yet the rule has remained frozen in time as if nothing has changed when everything has changed. As the world has changed, so too must the rule change. And the time is now for the Department of Labor to act. It has considered this proposal for years. It has sought and received input from all stakeholders, including in particular industry. It has addressed many of the industry's concerns and incorporated many of their suggestions into the proposal, including their priorities. Yet they continue to object, and the reason is clear. They simply do not want to change the status quo and work under a simple principle, a rule that says you must put your client's interest first. The industry's complaints, however, boil down to a false choice. Either brokers get to put their interest above their client's best interest, or they won't serve those clients. That's a false choice. The real choice is this. Let the DOL act to protect 100 million workers and retirees across this country, or continue letting brokers and other advisors put their interest ahead of their clients. That's the real choice. If some brokers don't want to do that or feel that they can't make enough money doing that, then there are plenty of retirement investment advisors who are more than willing to put the client's interest first. And frankly, today, there are tens of thousands of advisors doing that right now across the country with fiduciary duties, low cost, best interest of the client, serving them today, literally hundreds of thousands. In conclusion, we all agree we have a very serious retirement crisis in this country. Not enough people are saving for retirement, and too many of those that do aren't saving enough, as the chairman said in his opening statement. They need to keep every penny in their retirement accounts and not in their brokers' pockets. That's why updating a 40-year-old rule is so important, and why putting the client's best interest first is imperative. Thank you, and I look forward to your questions.
Thank you. Mr. Kelleher, Dr. Reed, you're recognized.
Thank you, Chairman Rowe and Ranking Member. I am Brian Reed, Chief Economist of the Investment Company Institute, a leading global trade association representing mutual funds and other regulated funds in the United States and around the globe. I'm here today to discuss the economic analysis that the Department of Labor uses to justify its proposed rule defining fiduciary duty for retirement advice and services. I've spent a lot of time with the DOL's regulatory impact analysis, and I regret to say that it is fatally flawed. Its analysis is an exercise in storytelling, crafted more to support the department's agenda than to measure accurately the proposal's impact on retirement savers. In fact, the economic analysis raises the question of whether the DOL fully understands the market for retirement advice. The DOL justifies its proposed rule by claiming that this market suffers from a substantial market failure, resulting in serious harm for retirement savers who invest through broker-dealers. But the department's assertions do not stand up when tested against actual data and experience. Even worse, the DOL's proposal could actually have significant net social harm. I have 5 points to explain why. First, the DOL's analysis is flawed when it claims that retirement savers will lose as much as $1 trillion over the next 20 years without its rule. The DOL reaches this number by arguing that brokers who are paid commissions through front-end loads on mutual funds are directing their investors into funds that underperform. But a simple test with data drawn directly from the market since 2007 shows just the opposite. Investors who own mutual funds with front-end loads actually bought funds that outperformed, not underperformed, the average return for their fund category. This one finding eliminates almost all of the rationale that the DOL uses to justify its proposal. Second, the DOL ignores market realities and the fact that investors may end up paying more, not less, for the advice under its proposal. The DOL predicts that its rule will drive down brokers' fund commissions by almost 2/3, but will not drive brokers from the retirement market. That seems highly unlikely to me. Furthermore, the DOL ignores the costs that investors will face if brokers do exit the market. The DOL estimates that investors are paying up to 28 basis points a year in front-end loads, but advisors charge, on average, almost 4 times as much for alternative fee-based accounts. If the DOL rule forces savers into fee-based accounts, savers may end up paying more, not less. Third, none of the academic studies that the DOL uses addresses the core question, whether an investor's performance is different when her advisor is a fiduciary compared to when her advisor is not a fiduciary. Thus, the DOL does not actually measure and cannot measure, based on these studies, whether an investor will get better results using a fiduciary advisor. Fourth, the DOL fails to identify and analyze the significant harm to savers that this proposal that could likely result from this proposal. With the new burdens created by the DOL's proposed rule, the high minimum balances typically required for fee-based accounts, it is inevitable that many IRA investors would no longer be able to obtain advice at all. Retirement savers will be worse off if they do not have access to assistance and advice. Finally, data show that IRA investors are concentrated in lower-cost funds, not higher-cost funds. The White House Council of Economic Advisors has widely promoted an estimate that IRA investors lose $17 billion a year through underperformance, largely stemming from excess fees. The CEA report uses a hypothetical calculation to argue that, on average, IRA investors pay 1 percentage point a year more in fund fees than do 401k investors. If we put actual fund data into the CEA's calculation, the difference between what IRA investors pay and what 401k investors pay is 85% less than what the CEA assumes. Now let me be clear, the ICI has long supported the principle behind the DOL proposal, that financial advisors should act in the best interest of their clients when they offer personalized investment advice. Unfortunately, the DOL's proposed rule is hopelessly complex, confused, and unworkable. As the subcommittee recognizes, this issue is vitally important to American workers and their families. Research by ICI and others show that the U.S. retirement system is working to help deliver a secure future for millions of Americans. But those successes depend on workers' access to advice and services. Any policy that impairs retirement savers' ability to get that help that they need will significantly harm the prospects of millions of workers. Unfortunately, the DOL proposal will do just that. I look forward to your questions.
Thank you, Dr. Reed. Mr. Harmon, you're recognized for 5 minutes.
Good afternoon, Mr. Chairman, Ranking Member Polis, and members of the subcommittee. I'm Dean Harmon, founder and managing director of Harmon Wealth Management in the Woodlands, Texas. I'm here representing the Financial Services Institute. FSI advocates on behalf of independent financial advisors and independent financial services firms. FSI is a strong supporter of a uniform fiduciary standard, but unfortunately, the Department of Labor proposal is unworkable, complex, and costly. Let me make it plain. This proposal will harm retirement investors. Let me start by sharing one of the ways this proposal is unworkable. For a client to be able to pay for my services using a commission model, my firm would have to comply with the requirements of the best interest contract exemption known as BICE. BICE requires that we give clients an estimate of all investment costs for 1, 5, and 10-year periods. In order to do this, I would need to predict investment performance. This will put me in direct conflict with SEC and FINRA rules. These projections may also create unrealistic expectations for investors. The proposal is also too complex. For example, BICE requires that firms maintain a machine-readable public website and update it quarterly. This website would disclose compensation received by the advisor, the firm, and any affiliates for every investment product sold. In the investment model, financial advisors have access to in the independent investment model, financial advisors have access to a wide variety of investment options. All of these investment products have unique pricing structures. Every single mutual fund family may offer as many as 500 or more versions of its fund. Compiling, presenting, and maintaining the required internet disclosures will be a massive undertaking. This complexity of the project could lead to inadvertent errors which may result in litigation. More importantly, the complexity may confuse investors and discourage them from saving for retirement. This proposal is also just too costly for investors seeking retirement services. They may encounter high costs as financial advisors are faced with a mountain of regulatory burdens that lead advisors to institute or raise asset minimums on retirement accounts. Because of this, investors of moderate means will find it difficult to gain access to valuable retirement advice and products. I do not want to turn away a potential client who needs my advice, but that will be the consequence of this proposal. That last point is so important. Let me give you an example from my own practice. I manage about $200 million in assets for 618 clients. Of those total assets, $10 million are held by 331 clients with an average balance of $30,000. These clients are mainly lower net worth, elderly, or young professionals just starting out. For these individuals, an advisory fee model does not make sense. A commission-based model is appropriate for them because it eliminates the out-of-pocket costs and provides a way to pay for the advice, products, and services that these clients need. I want to ensure that any written rule by the Department of Labor will make it easier for these investors to continue receiving high-quality retirement services from a trusted financial advisor, but this proposal fails them. In conclusion, FSI supports a uniform fiduciary standard. We will continue to work with the Department of Labor to protect investors and expand access to retirement advice. Unfortunately, the current proposal is unworkable, it's complex, and it's costly. Thank you, and I'll look forward to any questions that you may have.
Thank you, Mr. Harmon. Thank all the panel for your testimony. I will now recognize Dr. Fox for 5 minutes.
Thank you very much, Mr. Chairman. I appreciate it. You gentlemen were all here, and you heard the Secretary, and of course we never have enough time to ask the questions and get answers that will be helpful, but I intend to ask him this question in a follow-up and hope I can get some kind of a specific answer. He kept saying that it is a structurally flawed system, but he never truly identifies what that is, except saying he doesn't think best interest of the clients is always done. I'd like to add, and I'd love each of you to respond, perhaps not today, but I'd like to get an answer from each of you. But I'm going to ask Mr. Mason and Mr. Harmon, if you would answer. Can you tell from what the Secretary has said exactly what the structurally flawed part of the system is? And would this fix that? I think you've said no already, but does it work except for very bad actors that might violate any system that is put in place? Mr. Mason.
Yeah, I think just on your last point, a lot of the horror stories that we hear that are really just upsetting to hear and are illegal under current law. So, I mean, in terms of, is this a structural flaw with present law? Some of these horror stories, absolutely not. A lot of these things are illegal under current law. The only thing that I got out of it, and I don't speak obviously for the Secretary, but the thing that I got out of it today was the core principle that advisors should act in the best interest of their clients. And that's an issue in which there is, in terms of the people who've spoken, both up there and back over here, there's been unanimity. The one disagreement that is essentially they've come up with this exemption from the privy transaction rules that you have to go through in order to provide help to small accounts. That I talked to dozens of financial institutions, and there's not one who can use it. So it's the issue that they're trying to correct, best interest, that's fine. The way they went about it doesn't work.
Mr. Harmon, before you answer, I'd like to say what I got from his comments is that they want equality of outcomes. They want guaranteed outcomes for everyone. It seems to me that that's it, that they want maximum benefit. Well, all of us want that, for heaven's sakes, but there are risks associated. So, Mr. Harmon, if you have any additional comments to what Mr. Mason said.
I think Mr. Mason's points are right on point. Currently, advisors are highly regulated as it is. So we've had this current structure for many years. I don't think it's broken. I think we need to have the ability to provide multiple solutions for clients based on what their individual needs are. So I don't think the current structure is broken at all. And in fact, the current structure allows us to serve clients in different ways based on different needs, especially the moderate and lower income clients. Their needs are oftentimes different than what we would consider to be high net worth clients, and the options and products that they need available also need to be preserved.
I also think there's a problem with, again, who will ultimately decide what is in the best interest of the client. And I truly believe that that's just going to result in a lot of lawsuits because you pretend this 8-ounce cup has 4 ounces of water in it. Is it half empty or half full? Who defines what the best interest is I think ultimately going to be decided in the courts and by expensive trials. So thank you all very much. I yield back.
Thank you, gentlelady, for yielding. Mr. Scott, you're recognized for 5 minutes.
Thank you. Thank you, Mr. Chairman. Mr. Mason, you mentioned the $4,000 fund and said a 1% fee would be insufficient to make it worth your while to give advice. How much money would you have to get out of that fund to make it worth your while?
Well, I'm not in the business, but different financial institutions set different minimums in terms of how much they will require for an advisory account like that. Some of them, for example, are $100,000 or $50,000. In order to accept 365-day liability and responsibility, you really can't do it for $40. It's not economically sound.
But
so the
basically-
different I'm sorry, go ahead.
Basically, the $4,000 fund amount would be problematic whatever you're doing.
No. See, actually not, because under the brokerage model, what happens is it's a completely different relationship. Suppose I have to act in the best interest, but I'm under the brokerage model, and Jack were to come to me and ask me for help. I could give him help on that particular transaction, but I would have no ongoing duty to counsel him with respect to what to do tomorrow or the next day. That's the transactional model that has worked very well to help the low and middle income individuals on a much less expensive basis get the assistance they need. So it's a completely different model, and that's why the advisory model doesn't work.
Now, under the rule, if you're doing just a transaction, are you covered by the best interest?
Absolutely. In other words, again, Jack comes to me and asks me for my advice under our sort of scenario and under the Department of Labor's. You would have to give advice that's in the best interest, and we would support that absolutely.
Okay. Mr. Keller, doing a single transaction and somebody comes to you for the transaction, are you subject to the best interest under this rule?
Yes.
On a single transaction?
I'm sorry?
On a single transaction?
One of the loopholes in the current rule is that if it's not on a regular basis, then it falls outside of a fiduciary duty. And one of the things the new rule is intended to do is to capture actual substantive retirement advice, even if it's only one time.
Okay, but if you just ordered the mutual fund, you wouldn't be subject to it, right?
It depends on the context, as I understand the rule, is that if you were giving substantive retirement advice...
If you're giving advice?
Right.
Okay.
And it's very clear in education and call centers. Not every person who works in a call center is going to become an advisor. In fact, there's a very broad description as to all sorts of advice that people can use at call centers and elsewhere. And in fact, the rule on that point is specifically tailored to the input by the industry on this very issue. It hasn't taken away their complaints, notwithstanding they've been addressed rather extensively.
Okay, now Chairman Rowe mentioned an investor who was very satisfied because the size of their investment went up over the years. He didn't say how the investment measured compared to an S&P 500 fund. If you're going to evaluate advice over the years, what should you compare it to?
Well, one of the things that this is focused on is if you put the client's best interest first, then you can actually evaluate on a level playing field the chairman's example as well as the secretary's example. The problem now is that with the very low suitability standard, which allows the broker or the advisor to act in their own best interest above the best interest of their clients, you don't actually know whether and I can't remember the chairman's example, I think it was $365,000 the account grew to, that may or may not be actually a good return. If it's a return and the broker ended up getting 5% at the front end and they lost, as Jack Bogle would say, the tyranny of compounding cost, and every year he lost X%, where a similar product he could have been put into, he well could have had $495,000, $500,000 or more. You don't know because no one's required currently to act in their best interest, and that's the core of the problem. Many of the problems and complaints go away if everyone is required to put the client's best interest first.
And let me ask Mr. Haley a question. As I understand your testimony, you're comfortable with the best interest rule. You just want it administered in a way that can be easily administered. Is that right?
That's correct.
And can you help write the language where the best interest standard is used, but it does not have the complications that you see in the present rules?
Yes.
Thank you, gentlemen, for yielding. Just for clarification, that IRA was my wife's. It did beat it did beat the S&P, and I happen to know very close because it's in my own family.
And the costs.
Mr. Allen, you're recognized for 5 minutes.
Well, just for the record, I'm a little nervous that the Department of the Federal Government that owes more than $18 trillion would be working on a rule that overreaches about fiduciary responsibilities. That would make us all nervous, I think, sitting here. But Mr. Harmon, as you said in your testimony, that as an investment advisor, based on this rule, you would have to predict what your client would earn?
Yes, it's my understanding under the current BICE exemption that in order to be able to predict fees on an account for a 1, 5, and 10-year period, you also have to make assumptions as to the returns that the asset allocation of the investment would make.
Basically, under the current interest rate policy of this government, you'd have to recommend that your folks have 60 basis point earnings in their programs.
You would have to...
For guarantee.
Yeah, you would have to come up with some assumption that the portfolio would return at a certain rate.
And Mr. Mason, if this rule eliminates the brokerage side of the business, how big is that business? What percentage of the total financial industry is? Any guess on that?
98% of the IRAs under $25,000 are held in brokerage accounts. So the damage that would be done to the small investor is incalculable. 98% of the IRAs under $25,000.
That's unconscionable to me. I mean, I sit here and I just cannot believe, I wish y'all had gone first. Because I think I'm a little more educated about what really is going on here. Mr. Haley, you said that, again, you answered the question as far as support a best interest regulatory rule. In your mind, did the Department of Labor come to any industry experts and ask them what they thought about what might be in the best interest of the investor in this situation?
I'm not aware of that. We have had conversations with them in response to their proposed regulations, and we're waiting to hear what their response is.
Okay, so you have any idea where, I guess I should ask the Secretary of Education, that's why I wish he'd have gone last. Where did they come up with this rule? Does anybody know that? I mean, who wrote this thing? If it wasn't the industry, who is actually responsible for this?
I think that what happened was back in 2010, they thought that, well, these rules are out of date. And I think that the one piece that was really overlooked in this calculation was essentially, and again, I hate to use this term, but the prohibited transaction rules, they're also out of date.
Right.
Because it's those rules that prohibit the brokerage model from functioning. And so what happened is they updated one piece of it and updated in a way which we have very grave concerns about. And then they really haven't updated the prohibited transaction rules, and those are the rules that cut off low and middle income individuals and small businesses from help. So if we can update, if they could update those to accommodate the new system, that's how we can achieve the best of both worlds, a best interest standard with workable rules that allow access to low and middle income individuals.
So the consensus would be is the rule does need to be updated?
I don't think the industry has any concerns about updating a rule to ensure a broader best interest standard. We're absolutely fine with that. It's really, if that's going to be the case, we absolutely have to update the prohibited transaction rules to make them workable for the world that exists today. Because right now, this would, just as you said, I mean, this would be a terrible development for the small accounts and the small businesses.
Mr. Haley, how do we solve this problem?
Well, the first thing is the exemptive relief under the BIC does not apply to small businesses. So if you think about Fidelity, how do we serve small businesses? Number one, we have over 8,000 small businesses with less than $100 million in assets or less than 100 employees. Today, when that 401k comes to us, they give us a request for a proposal. They're looking for the lowest fees. They're also looking for a prototypical document. We do that. They ask us, what type of investments would you like, in the portfolio? We're an open architecture firm. So when you think about it, one of our divisions is Fidelity's Funds Network. That's the largest mutual fund supermarket in the world. We have $1.4 trillion on our platform of non-fidelity assets. So I'm not conflicted. We give them a lineup. I actually like to tell the story. I am the largest distributor of PIMCO's mutual funds, okay? In addition to being—
Mr. Haley, Mr. Allen's time's expired.
I yield the time I don't have.
Ms. Palamici, recognized.
Thank you very much, Mr. Chairman, and thank you to the witnesses. You've been here a very long time, and I'm glad you're all here. It's been a very enlightening conversation. I've always found that consumer confidence is really an important part of economic growth. It's good for businesses, large and small, when their customers know that they're being treated fairly and honestly. If you look back at the history of where the SEC came from, after the Great Depression, the SEC was formed, and those securities rules were written in order to bring that confidence back to the market. So it's a critical part, that consumer confidence, and it's important, as we've had this conversation about the critical issue of retirement security, that consumers have that confidence in their advisors and their transactions. So I'm really glad to hear this industry support for the best interest standard. And let me just clarify something real quickly, because I want to make sure I'm understanding what you're saying. Some of you have said the best interest standard, and some of you have said the best interest fiduciary standard. Does everybody agree that the best interest standard is a fiduciary standard? Does anybody not agree with that?
I think we agree.
Okay, great. That's really helpful. And I want to ask a couple quick questions and save time for Mr. Keller. But Mr. Mason, you and Mr. Harmon sort of brought up the same thing. I thought maybe for a minute you were law partners, because you're like Mason and Harmon, but I guess there's more than that.
There's no relation.
So, Mr. Mason, you said something about the brokerage model doesn't work under this rule for small accounts. And Mr. Harmon, you basically said the same thing, that this proposal will, I think you said, fail the lower net worth clients who pay on commission. And I'm confused about why, because the Secretary sat here and said commissions will be, there will be the ability to charge commissions under this rule. So can you briefly tell me why you say that the brokerage model won't work? And then I want to save time for a question for Mr. Keller.
I'm happy to, unless you want to.
Go ahead, Mr. Mason, go ahead and start.
Okay, I'm happy to do it. Briefly is going to be a challenge, because what it is there's a long list of requirements that essentially are non-workable. I will give you one example. I think there was a great discussion this morning on the contract rule about how you have to enter into a contract before you even enter into a relationship, and the Secretary indicated openness to sort of work on that.
Right.
But I'll mention one other that was mentioned by one of the members here this morning, which is one of the disclosures is to provide detailed information on every piece of direct and indirect compensation earned by the advisor, the financial institution, and every affiliate on every single asset that could be purchased by any retirement investor in the country. Well, there are thousands and thousands of different mutual funds. Did you just want to say something?
No, I just want to make sure that I have time left. And
yeah, I
thank
apologize.
you for pointing out
but
that. I know you said briefly it would be
difficult,
difficult, but I'm going to reclaim my time for some other questions. So that is very helpful. And Mr. Haley, you brought up the contract before the conversation, but that's not what Secretary Perez said. So, Mr. Keller, you heard the discussion, both with the Secretary and the discussion here today, about this problem that's been raised, or this issue that's been raised about the best interest contract exemption would require signed contracts before any conversations. But that's not what the Secretary said. So it seems like we're talking about two different things here.
Well, I mean, first, let's look at the facts. In 2010, the Department of Labor proposed a rule, and the industry says we're for best interest standards, and they killed the rule. And here we are again. What they said at the time is the rule's unworkable, withdraw it, consider our input, and repropose it. The Department of Labor did exactly, and I could give you the quotes from 2010, 11, and 12 from the titans of the industry who said that. So they withdrew the rule. They have done extensive outreach, unprecedented over the years with the industry. They have accommodated the industry. The industry said the world will end if we can't charge commissions. So working with the industry, the Department of Labor for years has figured out how to accommodate that complaint. They could have done what the UK did, ban commissions. And by the way, the statement earlier about the UK isn't accurate in terms of the response of the industry to that, the fiduciary standard without commissions, but they've accommodated the commission interest here. And yet, nonetheless, the industry is against it. So they say they're for a fiduciary standard, but they're never actually for the one that's pending. And it's interesting because every major labor, consumer, investor, and senior citizen group supports this rule. And a letter went to the chair and ranking of this committee today from I don't know how many, 40 or 50 of them, detailing that support. And you started with trust and confidence of the American people and investors. That's what this goes to. Put their best interest first, and you'll restore trust and confidence.
And I see my time has expired. I just want to note that there are other areas where there's a fiduciary duty, that we can get this done. And if you're all in agreement that we need to have this fiduciary standard, I don't see any reason why we can't make this happen. Thank you, Mr. Chairman.
Thank you for yielding. Mr. Rothman, you're recognized.
Sure, we'll have two short questions. Keep it short here. The first one, and I had another committee hearing, so maybe I missed if you dealt with it, Mr. Harmon. I had a little discussion about an hour ago with the secretary as to whether or not compensation paid to people was going to wind up on a public website. And I was citing your testimony here, and it was our testimony, this testimony, that it would be. Could you comment on that, or do you believe that under this rule, and, you know, kind of an interesting thing, that, say, if I work for a brokerage firm or whatever, that I can get on a people can get on a website and see how much I'm making?
I'm sorry, could you repeat it again? I was having a hard time hearing it. Just
okay,
there.
This is the deal.
Thank you.
I asked a question before the secretary, and I asked the question off of your expected testimony. It appears to me in your testimony here that you are under the belief that you can now, or if this rule goes into effect, you will be able to get on a website and see how much individual people are making. If you want to, I can, page 18, the website must be in machine-readable format and include the direct and indirect compensation payable to the firm, each individual advisor, and each individual affiliate of the firm for each asset available the last year. Okay, which looks to me like if I'm an employee of, you name it, somebody can get on a website somewhere, has the chance to get on a website somewhere and see I made $40,000 last year, $140,000 last year, whatever I'm making. Now, the secretary said, imply that that's going to be confidential and the website is only for, I don't know, not public use. But could you give me your opinion as to what's going on there?
Yes, absolutely. Thank you for the question. I guess one of the concerns about the website, my understanding is that it would be public under BICE, but one of the big concerns is context and information around context. I'm concerned that this will create additional confusion for investors because they don't know necessarily how to interpret this data and that. Then the other thing from a performance reporting standpoint that's concerning is every client has different objectives. And so back to kind of benchmarking that was mentioned earlier today, it's difficult to know one client from the next whether that was successful or not based on the fact that different people have different goals and different objectives for their portfolio, and their portfolios are managed differently to achieve those goals.
Okay, I mean, when I read your testimony, I take it to mean if I'm an agent for a captive industry or whatever, somebody can get on a website. Maybe that's fine. Maybe we should own what everybody else is making. It's just kind of an interesting thing that the proposal is that I can get on a website and see that John Jones made X amount of dollars last year. Is that the way you read that?
I do, and again, the public nature of that's concerning from a confidentiality standpoint.
Yeah, just an interesting thing. Now, my other question will be for Dr. Reed, and then we'll let you guys be. The administration claims that bad advice is costing $17 billion a year. Could you elaborate one more time as to how that figure is arrived at, or whether you think it's accurate?
Both the Council of Economic Advisors and the Department of Labor have argued, based on their reading of the academic literature, that individuals in brokerage accounts are underperforming by at least a full percentage point a year. The Department of Labor says perhaps 2 percentage points. This is actually a fairly easy test. You can go into the Morningstar data, you can look and see where the assets are holding for the types of funds that they're talking about in their analysis, you can actually find that the assets are concentrated in low-cost funds that outperform their Morningstar average. And so it's the claim that they do underperform by this 1 percentage point is not based in data or in actual experience.
Thank you. I yield the rest of my time.
Thank the gentleman for yielding. Mr. Sablon, you're recognized for 5 minutes.
Thank you very much. Mr. Harmon, you actually got me there in your testimony, but then the statement that investors would be underserved because they don't really know where to go to. Who's that investor you're talking about?
Which investors am I talking about? I'm talking about lower net worth and mid-sized clients, mid-sized investors as well. So people.
How much wealth do they have invested? Which is
really anyone with less than $50,000.
Okay. Yeah, I have just curious, and because I was very pleased with the response Mr. Haley provided Ranking Member Scott that there could be a way to work this thing out until Mr. Kelleher, okay, Mr. Kelleher, right, said that actually the department has. This is not the first time we've had this. I just got into the subcommittee, but that 2010, 2011, or 13, so that every time, why don't the industry get together with the Department of Labor and work something out that works for all of us? I mean, I don't think any one of you will say that you don't want to be known as not having the best interest of your client, but then why is it so difficult to get there when Mr. Haley says that we can? Without writing a rule to that it makes negligible any offenses to it. I'm just curious. I'm from the Pacific Islands, so I don't really know these things.
The way to align that would be to support a best interest rule. There are a lot of people running around saying, we support the best interest, we just don't want it to be in the rule. And they don't say it that way, and that's the problem. You know, today, there are 90,000 certified financial planners. There are 10,500 registered investment advisors with the SEC representing 200,000 individuals, all of whom provide services in the client's best interest. The sky hasn't fallen. They're making plenty of money. They're doing right by their clients. And the market proves that that's not only possible for the client to thrive, but for the business to thrive. And we also have these new entrants that were mentioned earlier. Rebalance IRA, Wealthfront, Personal Capital. Their entry is coming in from small businesses across the country, technology and otherwise, to serve small savers, small businesses, as well as large savers and large retirement accounts with a fiduciary duty. The only question is the rule going to put the client's interest first or the broker's? That's what we're talking about. That's the choice. And if everybody's going to say, I support the best interest rule for my clients, then stop saying it, step up, and support a rule that actually does it. 5+ years of warfare against the rule does not quite coincide with the pretty words.
But now let me get this straight. We spent 5 years trying to work out this rule. And whose fault is it that it's not yet a rule?
Well, I think if you look at what the Department of Labor has undertaken unprecedented outreach. Better Markets has participated in the rulemaking process across.
I have another question, Mr. Kellan, just out of curiosity, because again, I need an education of catch up on all of this. How much exactly is it costing the industry for government oversight over this investment? How much is it the cost of government oversight to the industry that they have to get their lawyers paid so that they could make sure everybody is following the rules?
You mean how much today?
What's the standard, say, is there an average, an industry standard, say 10%, 15, whatever?
I don't know if anybody's put a number on it, but I think everybody's conceded that it's a very highly regulated industry, and I think everybody concedes it's appropriate to be a highly regulated industry when you're dealing with people's retirement money, which is not only tax advantaged, but incredibly hard earned. And so it's appropriate that we have,
especially if it's mine,
for everybody, the right rules and the right laws in place so that the money from hardworking Americans is treated appropriately in their best interest, where they get the best return, lowest cost, best outcome.
Right. And again, I'm just afraid that Mr. Haley's agent will close shop if this rule. He's concerned about the additional cost for this whole thing.
There's also a cost, by the way, of no oversight.
Yes.
A rule that puts the broker's interest first is costing the American people a fortune. So there's actually a cost of poor regulation or no regulation as well.
I think the 5 years too is a little bit of time spent on trying to come to an agreement, and we have no agreement. So I agree. I yield back.
Thank you, gentlemen, for yielding. We mentioned, I'll finish the questions briefly. We mentioned the word trust, and the Secretary did. In all due respect to the Secretary, who do I trust more, the Department of Labor or my financial advisor? And I can guarantee you it's my financial advisor is looking after my interests a lot more, because he just texted me during this hearing. I just got a text from him. So I do, and I sincerely mean that. I have great trust in him, and I have a great relationship, a 20-year relationship with my financial advisor, and we will continue to do so as long as he is doing that business and I'm doing that. I think a few of the things I think we agreed on today, and I think this has been a great hearing, by the way, from the Secretary, is the best interest standards, and to update the rule that'll make it, and Mr. Sablon mentioned this, about making this happen. I think this can happen. I really do. I think everybody here in this hearing thinks it needs to be updated. It ought to be done, but it also ought to accommodate without the onerous. I mean, look, do you want to read? That's where the details are, not the little one sentence, but this is where the rubber hits the road, right? Believe me, as a doctor having to deal with Medicare, and by the way, I wish the Secretary would ask Medicare to be as transparent as he's asking these financial people to be. That would help me a lot in my work. But I think that I heard Mr. Carter say it, I've heard others say it here, is that we don't want this to get so unmanageable because somebody pays the bills here, and it's always me, the client, that does that. And I want Mr. Harmon to answer this question, if he would, just a second ago, and I mean, he mentioned a minute ago, that confused me a little bit. In the new rule, it says you have to predict future earnings, and every time I have ever picked up any mutual fund or looked at it at all, and full disclosure, Fidelity has some of my retirement account, to make that public, past performance doesn't predict future returns. I hear it every time. Is that a conflict, or how do you reconcile those two things?
No, it is a tremendous conflict, I think, and you mentioned trust in your statement here, and that has the potential to significantly undermine trust. Simply that alone, by putting that in there. Because as we know, things are not static. They don't always end up 10 years from now exactly as we might think they would today, even though we're making the best interest, best recommendation for the client at that point. So that is problematic, and it's problematic that it crosses current FINRA and SEC regulations as well. I think it
absolutely does. I think you cannot now go out, and my advisor can't go and say, I'm going to guarantee you, or you're going to probably make this much money. He's never said that in my life. I've never heard him say that. The market is volatile. We certainly saw it in 2000. Look, I've been through the recession of 81, through the later recession in the later 80s and 2000. I mean, and they'll come again. This is not the last recession we've had. Hope it won't be as bad. But let me ask one other question. Is it true that higher cost plans, Dr. Reed, always yield a lower cost? And Mr. Kelleher mentioned a minute ago about it happened to be a family member's IRA that was a managed account like that. Look, I don't care if I pay 3% on a load if I make 12 and my net is 9. I'm looking at my net return and not just what I pay in a fee, because I may get a better return. I may not. Is there a data out there in the industry to show that?
So, Mr. Chairman, I think this obsessive focus on fees alone, and even a fiduciary standard doesn't say that it has to be the lowest cost fund, can really be blinding. So much so that the train can leave the station and you are not on it. And what do I mean by that? What I mean is that investors who were not properly allocated to the market, who didn't have enough equity exposure, completely missed the market run-up since 2008. We have been in the most vigorous bull market in the stock market, probably in the last 100 years. And yet, as one of the panelists has indicated, 45% of government employees in the TSP are in the G fund, which basically makes just enough to get above inflation. That is evidence when you don't get help and advice how much you can lose out. It's a cheap alternative, it's low cost, but they missed the train.
Would someone just mention briefly the website? That was confusing me what the secretary said. Who would have access to this website with all this data? Would you have to sign the contract? Is that how we'd get access to the website, or how does that work? Does anybody, because you heard him say that.
For example, every participant in an entire plan, so if you have 100,000 participants in a plan, every single participant would have access to the information that's stored
In that website. Well, I want to thank you all very much for your participation. Been very patient sitting through a long first panel, and I will yield to Ms. Bonamici for closing remarks.
Thank you very much, Mr. Chairman. And first, I would like to enter into the record the letter referenced by Mr. Keller, dated June 16, 2015, from various organizations in support of the rule. I'd like to enter that into the
Without
record.
objection, so ordered.
Thank you very much, Mr. Chairman. And I'm going to give the opening statement on behalf of the ranking member, but I want to say that I'm an optimistic person, and when I hear everyone has the same goal, the best interest fiduciary standard, and there's some definitional differences about how we get there, I'm confident that we can get this done. And I get to say this because I also serve on the science committee. It's not rocket science to get this done. So we're a long way, 40 years away from when the days when most people had traditional pensions to rely on in retirement. The shift away from defined benefit plans has exacerbated retirement insecurity in this country, and the proposal we've discussed at length today modernizes this outdated fiduciary rule that was developed when the defined benefit plans were the standard, which is certainly not like today. At the end of 2014, $7.4 trillion in U.S. retirement assets could be found invested in IRAs. Much of that had been in ERISA-covered plans before being rolled over. And $6.8 trillion could be found in private employer-sponsored defined contribution plans like a 401k. Individuals with little to no financial expertise must determine their own retirement strategy as well as make complicated investment decisions in order to prepare for retirement. Too many middle-class and working families are worried about saving enough for retirement, and it's critical that when these individuals seek advice from professionals, they receive recommendations and advice that is in their best interest, rather than conflicted advice that's in the best financial interest of their advisor. Unfortunately, conflicted advice has been permitted under the standard we've been operating under for the past 40 years. The department's proposal, which they have been working on for years with input from the industry, is reasonable and affords participants the access to all the necessary information available to help them make informed retirement decisions. We look forward to continuing to work with the department to ensure that the final rule appropriately addresses concerns. Thank you very much to the witnesses for such an enlightening hearing.
Thank you very much for yielding. In conclusion, we do have a situation in America today where not enough people save for retirement. We know that. 29% of people over 55 don't have any savings at all. That's just frightening when you think about it. It means they're going to have to, and life expectancies are going up and up and up, so it puts great strain on social services. So we need to, and I believe this, that the day I started practice, we had a pension plan for every employee that was in our practice, and we still do to this day. And many of you, and certainly Mr. Harmon, you do, have individual small investors. Fidelity is a huge company. You're a smaller business, of course, but you provide a tremendous service for people and advice that help people who are not sophisticated investors gain knowledge about how to invest their money and how to save for the future, and give them a lot of confidence about how they're going to live when they get older. And I can assure you, having a mother that will be in assisted living right now and knowing those costs and so forth, you can't save enough money. I don't know if anybody ever said they saved too much money. And that's obviously a challenge that we all have. We have a big problem that we work through on multi-employer pension plans. You remember that's still a serious problem that we haven't completely solved. So saving for our future and for our retirement is a national problem. We need to make that easier, not harder. I certainly heard very encouraging things here today from the Secretary and from industry about the best interest fiduciary standard. I think all of you support that. No one supports conflicted advice. No one that I know of does. So I think we need to hopefully work this out, and the BIC exemption is not workable. I mean, I've tried to sit down and figure out, and I've already heard from Mr. Haley, again, full disclosure, our small business is not going to be able to get advice because Fidelity is our brokerage service for our business, and I just realized when he said what he said that we won't be able to get advice from Fidelity with this new rule. That's ridiculous for a group that's trying to do the right thing by its employees and its folks that work for them. So I thank you all. It was a great hearing. If there's no further comments, the hearing is adjourned.